Welcome to Coordinating Minister for Law, Human Rights, Immigration and Correction Institution of the Republic of Indonesia. Profesor Dr. Yusril Iza Mahendra, SHMSC.
And Rector of Universitas Andalas, FIND PhD.
Ladies and gentlemen, please be seated. Once again, ladies and gentlemen, please be seated. Well, ladies and gentlemen, that was an outstanding performance by Studio Merah, Faculty of Law, Universitas Andalas, Tambua Tasa.
Ladies and gentlemen, let's sing to our national anthem, Indonesia Raya. Please rise. Thank you. Please be seated.
Wow, good morning, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. And warm greetings to everyone joining us here at Universitas Andalas.
Welcome to the first Andalas Law Conference 2025, Creating the Dam, Legal Reform and Equitable Law Enforcement in Indonesia. I'm Nada Salsabila Putri Wandina.
And I'm Fifa Zahara, and we are truly honored to be your host for today's international seminar. And before we begin, allow me to extend our warmest greetings to Coordinating Minister for Laws, Human Rights, Immigration, and Correction Institution of the Republic of Indonesia, Professor Dr. Yusril Iza Mahendra SHMSC.
Rector of Universitas Andalas, Eva Yunedi, PhD.
Dean of Faculty of Law, Universitas Andalas, Profesor Dr. Ferdi SHMH.
Keynote speaker, Professor Tim Lindsay from Melbourne Law School.
And to our guest speaker, Dr. Prim Haryadi SHMH from Supreme Court Justice.
Professor Simon Butt from University of Sydney.
Profesor Dr. Idewa Gede Palguna, SHMH, Faculty of Law, Udayana University.
Rolly Francis Canlas Pero San Sebastian from College of Law.
Professor Christy Warren William and Mary Law School, Virginia, USA.
Dr. Bill Swaney from Australian Catholic University.
Profesor Dr. Ahmad Hidayat, Buang University, Malaya.
Nur Syarifah Auriga Nusantara.
And Jovita Dorosario Amaral, East Timor presenters. And to bless today's event, let us pray together. And prayer will be led by Mr. Muhammad Zafif Zulka.
Bismillah. Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala asrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Allahumma ighfir lana dzunubana wa liwalidina warhamhum kama rabbawna shighara. Allahumma ighfir lil muslimina wal muslimat wal mu'minina wal mu'minat al ahya'i minhum wal amwat innaka ala kulli syai'in qadir. ربنا لا تؤاخذنا إن نسينا أو أخطأنا ربنا ولا تحمل علينا إصرا كما حملته على الذين من قبلنا ربنا ولا تحملنا ما لا طاقة لنا به واعف عنا واغفر لنا وارحمنا أنت مولانا فانصرنا على القوم الكافرين ربنا لا تزغ قلوبنا بعد إذ هديتنا وهب لنا من لدنك رحمة إنك أنت الوهاب ربنا ظلمنا أنفسنا وإن لم تغفر لنا وترحمنا لنكونن من الخاسرين ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين. Assalamualaikum warahmatullahi wabarakatuh.
Now, it is my honor to invite Rector of Universitas Andalas to deliver the Rector's welcome speech. To Eva Yunadi, PhD, the stage is yours.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera buat kita semuanya. Am I supposed to speak in English or in bahasa Indonesia? In English, because it is in bahasa Indonesia. All right. His Excellency Professor Yusril Ihza Mahendra SH MSc, the Coordinating Minister for Law, Human Rights, and Immigration of Republic of Indonesia. His Excellency Dr. Prim Haryadi, SHMH, the member of Supreme Court of Republic of Indonesia, sorry for that, and His Excellency Professor I. Dewa Gede Palguna, Professor Tim Lindsay, Melbourne Law School, the Vice Rectors, all Deans, and the management of Universitas Andalas, respected speakers and keynotes, distinguished guests, ladies and gentlemen. My name is Eva Yonedi, Rector of Universitas Andalas. Hadir juga Pak Kakanwil, Kanwil Hukum, Kakanwil Pemasyarakatan, Kakanwil Imigrasi tadi, Kakanwil HAM ya. My name is Eva Yunedi, Director of Universitas Andalas. I'm actually trained as an accountant, and my research interest is on corporate governance. So this area is a new topic for me, and it is my great honor and privilege to welcome you at Universitas Andalas. Universitas Andalas founded in 1956, and it is now top 250 university in the world for interdisciplinary science research. And we are a public university which offer a comprehensive courses. We offer 154 study programs, and my job is to produce graduates that are able to compete beyond national job market, and also to produce research, disseminate research and innovation. And last election, Pak Menteri, we produce tinta merah putih, and it was used for general election during the presidential election. We produced 1 million bottle of ink, and that's product based on the patent from our researcher at Universitas Andalas. So Universitas Andalas currently has around 36,000 students, ranging from undergraduate, master, and postgraduate. So we are among top 10 university in Indonesia based on the Science and Technological Index. We are now ranked number 6 in Indonesia. And if we refer times higher education, Universitas Andalas now is ranked number 8 in Indonesia. And as a university, we are committed to investing more in education, research, innovation, and also to service the communities. It is our commitment to support this event, the first Andalas Law Conference, as a university which focus more on research and innovation. And this conference is very relevant to the strategic direction of Universitas Andalas. So I congratulate the Dean of Faculty of Laws and all colleagues at the Faculty of Law who have been working hard to conduct this first Andalas Law Conference. Thank you very much for your hard work, dedication, and commitment to plan and carry out this conference. And this conference is also supported by Indonesian Endowment Fund through the project of Equity Project, enhancement quality education for international recognition. So the Equity Projects facilitates our college and students to have more scientific program, international conference, and also visiting professors from all over the world. So we welcome international visiting professors, student inbounds, for example, a credit earning for 1 semester at Universitas Andalas to have an experiences not only studying at Universitas Andalas, but living in the culture of Minangkabau. Not only studying from our founding fathers, yeah, but also, you also have an experiences, how to cook rendang, how to taste rendang, and how, yeah, through this conference you will experience many types of foods and cultures, yeah, from Minangkabau. Lastly, I hope from this conference you will have many takeaways with you that challenge your current thinking, that motivates students to have more readings, and also motivate us researchers to have more research and more publication in the future. So enjoy the conference. Thank you very much for coming and visiting us at Universitas Andalas. And we look forward for more fruitful collaboration and more meaningful cooperation in the future. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you for the Rector of Universitas Andalas for your inspiring words.
Okay, now, ladies and gentlemen, we are deeply honored to welcome the Coordinating Minister for Law, Human Rights, Immigration, and Correction Institution to deliver the opening speech, Professor Dr. Yusril Iza Mahendra, SHMSC. The stage is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Assalatu wassalamu ala Rasulillah wa ala alihi wa sahbihi ajma'in amma ba'd. Honorable Rector of Andalas University, Honorable Dean of Faculty of Law, Andalas University, Honorable Dean, Melbourne Law School, distinguished speakers, distinguished provincial governments of West Sumatra, distinguished participants, ladies and gentlemen. Allow me to express my sincere gratitude for the honors of speaking before this distinguished audience of the legal scholars and practitioners. I highly appreciate the themes of the year's conference, legal reform, inequality, equitable law enforcement in Indonesia, a pursuit of legal reform and uphold social justice, and indeed our shared responsibility. As an introduction, allow me to recall the words of the late Professor Mustafa Maja, who once said that law is a means to maintain order and justice within society. This statement reminds us that the function of law must always oriented toward serving the people and ensuring justice, not merely the rigid rules. When we speak of legal reform, our imagination often drifts toward parliamentary buildings and legislative stacks. However, law is like an ecosystem. It not only grow from the state, but also live from judicial decisions, the customs of business actors and the legal professionals, the thoughts of the scholars, and the practices deeply rooted within a society. Law can emerge from various sources. It is not standing static, rather, it is the result of the dynamic interactions among different actors within a society. In legal scholarships, We often encounter the expression that law not solely states law, that is, law made by the state stroke legislations. Law can also originate from judiciary, judge-made law, where judge stroke their decisions create precedents, formulate ratio decidendi that guide future legislation and often upon the new norms. As I mentioned in my public lecture in Surabaya last October, law is not only the state's law produced by the state, but also the judgment law, the lawyer's law, the professor's law, and the people's law. All of these schools of law, including social traditions, interact to form our legal system. Therefore, the government's task is not choose one source of law of another, but rather to harmonize them, all so that our national law may live, breathe, and stand for justice. Furthermore, there is what we call lawyers' law that develops through the practice of lawyers and legal professionals, shaped by procedural customs, contract, corporate governance code, and compliance guideline. Also often referred to as a soft law, it is the regulatory power is tangible, as it's been the practice the parties involved in face regulatory gaps. There is also professor's law, which emerged from the ideas of the scholars at the university, legal doctrines, academic teachings that later influenced the legal practice and judicial decisions. In many instances, academic doctrines serve as the authoritative references for interpreting norms. And finally, no less important, there is people's law, customary law, religious law that grows organically from the customs, tradition, religious teachings, and unwritten social norm at communities, yet exerts the strong influence. People's law may take the form of customary practices or community based dispute resolution mechanisms. In many legal systems, such living law is recognized as long as it does not contradict national law or human rights principles. By understanding the various sources and creatures of law as described above, we can also anticipate where the legal reform originates. Legal reform might arise from the state initiative or, for instance, through legislative reform designed to address contemporary challenges. The state undertakes reform as a response to shifting public policy needs when the digital economy demands personal data protection, when the climate crisis confronts new governance over natural resources, or when demographic change and urbanization alter patterns of the legal dispute. However, reform may also emerge from the judiciary when judges reinterpret existing laws in a new ways, creating reform for judicial decisions, much like the Constitutional Court and the Supreme Court have done in the many countries. These institutions often act as the locomotive for the reforms toward the progressive interpretation of the Constitution. In addition, reforms may come from society itself, such as stroke social movement. Consider how Indonesia's anti-corruption movement led to the establishment of the Corruption Eradication Commission and the enactment of various new legislation, or how the human rights movement encouraged the ratification of numerous international conventions. Lawyers and legal practitioners also frequently play a vital role as catalysts of the change the drafting initiative for contracts models for engaging advocacy drives policy transformation. Many landmark judicial decisions were inspired by the creativity and boldness of the legal argument presented by the lawyers, which is turned prompted progressive judicial breakthroughs. Legal reform may also emerge from academic doctrines. Theoretical ideas expressed through expert opinion in court, academic papers, or scholarly views presented in parliamentary hearings often serve as a key inspiration for the legal reform. If we observe development across various countries, it becomes evident that legal reforms doesn't always originate from the legislative reform initiated by the government or parliamentarian or the politician, but come from the public, come from the people, come from the academic in various universities. Ladies and gentlemen, let us take a historical perspective. Our legal system is a result of the long accumulation of influence by various sources of law. Even before the arrival of the Dutch, the people of the archipelago already pressed the adat or the customary law and the Islamic legal traditions that were deeply embedded by their daily life. The Dutch colonial era introduced the Roman Dutch legal system, such as the Burgerlijk Wetboek or civil court, the criminal court, and the court of criminal procedures, which was initially applied only to the Europeans, but later extended more broadly. During the Japanese occupation, the legal structure shifted toward the militaristic systems. After the proclamation of independence in 1945, Indonesia inherited numerous colonial regulations, yet we sought to establish a new legal foundation based on Pancasila, the state philosophy in the Constitution of 1945. The Pancasila doctrine, conceived by Supomo and his colleague, calls for the legal system rooted in the strengthened adat law and the Islamic tradition and the nation's cultural values. Therefore, even though the new order regime attempted to unify the law, adat law continued to be recognized as the soul of the Indonesian law. The era The reform era used the renewed spirit of transformation of constitutional amendment of 1999 to 2002, in which I had honor to participate. The enactment of the human right law and continuous effort for strengthen the judiciary and enhance public protection. From this long historical journey, we can observe that Indonesian law is inherently pluralistic, integrating Western's nation of the rule of law, social cultural conception of justice, and the moral foundation of the religion. Legal reform might originate from diverse sources, driven by a wide range of actors. Indonesia possesses unique characters that make the process of the legal reform fascinating and challenging. We live in a crossroad, the three powerful legal traditions, Western law, which introduced codification and modern institutions, Islamic law, which governs matters of personal status and has rapidly expanded in the field of Sharia economic and other customary law, which reflects the sense of justice within the local communities. The constitutional duty of the government is not choose one of sources, one part of the legal reform of another, but to orchestrate all the legal systems to recognize the living law without undermining the equality, to develop Sharia-based system within a framework of the professional governance, and to ensure that codified law remains relevant in response to the changing world. From my personal experience, I have been privileged to gain extensive insight into legal reform. As Minister of Law and Legislation, and later as the Minister of Justice and Human Rights Affairs under President Abdurrahman Wahid, and subsequently as Minister of State Secretary under President Susilo Bambang Yudhoyono, I had the opportunity to learn firsthand how legal policies are formulated and implemented. During the period, I was also entrusted as a member of the drafting team for the amended 1945 Constitution. Now, as the coordinating minister for law, human rights, immigration, and corrections, I once again bear the significant responsibility of overseeing the entire national legal systems. In addition, I have served as a professor of constitutional law at the University of Indonesia since 1998, making the academic world an integral part of my professional calling. With this background, allow me to share a few reflective thoughts drawn from intellectual, practical, and technocratic experience. The law must grow from the concrete experience of the people, not merely from the theoretical abstractions. However, our journey of the legal reform remains unfinished. We continue to witness a stark gap between the formal law written on the paper and sense of justice felt by the people. Too often, the poor find themselves trapped by the rigid regulations, while wealthy escape punishment. As Professor Chipto Raharjo once stated, law exists for human beings, not human being for the law. This means that the law must serve the needs and the human values of the society. It is within the context that we must observe the classical phenomenon of injustice. Justice is not always achieved merely through procedural or formal equality, but justice must also ensure accessibility and substantive justice. The Indonesian law media even wrote the justice is not merely formal equality before the law, but substantive equality. This means the affirmative measures are needed to provide special protection for those who have been structurally marginalized from the very beginning. Nevertheless, various positive steps have been taken to expand access to justice for the people. One of these initiatives is the establishment of the legal aid post or post bantuan hukum or post bakum, which serve as the quick response mechanism to the public's need for inclusive and easily accessible legal aid services, particularly in the rural areas. These programs aim to expand access to justice in an equitable manner. This year, the National Law Development Agency, or Badan Pembinaan Hukum Nasional, has set a target to establish 7,000 post bakum out of the approximately 80,000 villages sub-district across Indonesian territory. As of October 1, 2025, there are already 36,547 post bakum established through the country. Ladies and gentlemen, in the digital area, legal challenges have become increasingly complex. Technologies such as artificial intelligence, blockchain, and smart contract have begun to penetrate the legal domination, demanding the judicial system to adopt. The Supreme Court has initiated in a transformation to the implementation of the court's e-court system and online publication. However, a shift in mindset of judicial approach is also required to anticipate the unique characteristic of cases in the digital age. At the same time, a new phenomenon has emerged on social media reflecting a crisis of trust in the legal system. No viral, no justice. Cases that go viral often receive greater attention from the law enforcement, while those do not tend to be overlooked. Recent studies reveal that the public pressures driven by the viral exposure, can indeed accelerate institutional responses, but also risk compromising the due process of law and creating disparities between viral and non-viral cases. As concluded in the study, justice should not be determined by the media exposures, but by the integrity of the legal system that upholds certainty, substantive fairness, and the protection of the fair citizen right. Therefore, public participation to social media must be accompanied by the balanced regulation. Authorities should remain responsibility without becoming reactive to the viral pressures, while the national judicial system must uphold the principles of equal treatment that every case, whether viral or not, must be handled fairly, transparently, and professionally. Still, within the framework of the substantive justice, it is important to highlight the impact of socio-economic inequality on law enforcement. Indonesia continues to experience a high degree of class disparity, which is reflected in how law operates. Frequently, unequal law enforcement for the exacerbate economic injustice. Ordinary citizens who dare to challenge cooperate or governmental policies are often perceived as the disruptors of the public order and can even be criminalized. For instance, villagers opposing national strategic projects are frequently charged under criminal provision for defending the customary land rights. Consequently, those with significant economic or political power often escape legal accountability even then their action harm to the public. The 2024 oil and gas mafia cases, the food crisis, and various project allocation scandals all reinforce the perceptions that the law has yet to deliver substantive justice. Therefore, the reform agenda must position law as an instrument to reduce inequality through legal policies that strengthen distribution and protects the economic rights of marginalized communities. Pro bono legal aid and access to justice for the underprivileged must be expanded. So, the principle of justice is not merely a moral ideal, but a tangible reality. Speaking of the legal development, several significant issues have emerged this year. First, the new Indonesian Criminal Code is set to come into full effect in early 2026. Article 613 of the new Penal Code, KUHP Baru, mandate the government to enact criminal adjustment law to ensure that all existing criminal provisions are harmonized with the new national criminal system. The government is currently expediting discussions of the bill to ensure that the implementation of the new criminal code proceed effectively without overlap with previous regulations. In line of this, several other legislative initiatives are also being prepared, including the law in the transfers of prisoners between the countries, the law of restorative justice, and the law on assets forfeitures. Collectively, these initiatives aim to establish a modern, equitable, and legally certain criminal justice system for Indonesia. Second, the law on the Indonesian National Armed Forces is currently undergoing a judicial review at the Constitutional Court, filled by the civil society coalitions. Several provisions in this law have drawn public attention as they are considered to potentially allow active military personnel to hold civilian positions, thereby blurring the line between the military and special and civilian spheres. Such a situation could undermine the principles of the civilian supremacy and heighten the risk for the politicization within the security apparatus. Therefore, it is crucial to ensure that democracy and the rule of law are not compromised by the short-term political interests. Third, the ethical crisis within the judiciary continues to recur. Recently, the public has been shocked by the several problematic judicial cases. For instance, the designation of three judges from Surabaya District Court as suspect in the bribery case involving Ronald Tanur underscores the urgent need to restore the integrity of the judicial institutions. Such incidents highlights the continued necessity for strict oversight and professional ethics development for members of the judiciary. Fourth, human rights issues remain a major challenge for our nation. Cases of human rights violations continue to occur across various regions, particularly those involving abuse of authorities, social conflict, and restriction of freedom of expression. The civil of armed conflict in Papua and the poor enforcement of human rights demonstrate that our policies must prioritize civilian protection and humanitarian dialogues. Similarly, issues such as torture in law enforcement, criminalization of expression, and the protection of humans and children's rights frequently arise. Building public trust requires consistent human rights enforcement, transparent and accountable investigation of violations, and the protection of the vulnerable groups in the justice system, such as female detainees, children, and persons with disabilities. In the context of justice reform, we must also pay special attention for the indigenous communities, women, children, victims of violence, prisoners, persons with disabilities, and other vulnerable groups. For example, harmonizing the national law with customary law is crucial for the social justice because, as Professor Supomo stated, customary law is the soul of the Indonesian law. The grassroots realities of the indigenous communities must be respected in policy making in law enforcement. Development must not come at the expenses of their land rights and cultural heritage. Similarly, women and children require extra protection from violence and discrimination. Institutions for child protection, special units for handling cases involving women, and the fulfillment of the children's rights to education and health care must be strengthened so that future generations can experience justice. Among persons with disabilities, the implementation of disability law has not yet been fully effective as social stigma and physical cognitive barriers to accessing the court still need to be addressed. Special attention must also be given to the prisoners and correctional inmates. Our correctional systems still often emphasize punishment, retribution, while neglecting rehabilitation. Many correctional facilities operate over capacity, and inmates frequently do not receive skills training necessary for the reintegration. Yet, the ultimate goal of the criminal law is to return citizens to society as productive members. Therefore, we must shift a reintegrative approach, providing programs for social development, education, and mental health within correctional institutions. Incarceration should not be merely confinement, but a process of restoration. This requires collaboration between the Ministry of Law and Human Rights and the Ministry of Social Affairs, as well as support from the universities to develop training models that have real impact. Indonesia's public sphere also called for the refinement of religious and customary law within a constitutional framework. Discussion on Islamic law frequently arise, such as reform to the marriage law, profession criminalizing adultery, or implementation of religious criminal law. It is necessary to balance the religious rights of Muslim communities with Indonesian diverse society. The government should approach this through collective ijtihad, aligning religious norm with the human rights principles and the constitution. Various reforms have already been undertaken, such as the establishment of the Kurdi religious affairs chambers to integrate the management of the Islamic law within the judicial system. Furthermore, the Hajj law, the Zakat law, the Waqf law, and provisions for chemical castration of the pedophile demonstrative the adoption of the Islamic law in a way that is responsive to the contemporary context. The guiding principles is that the Islamic law in Indonesia must be inclusive and adaptive, upholding the dignity and safety of the community without contradicting to the state basis of the Pancasila. The same applies to customary law. The recognition of the civil law in the new criminal code represent a significant step forward. The KUHP stipulates that customary law applies locally and must be regulated through regional regulations. Except in Aceh, of course, that Islamic criminal law implemented in Aceh as far as it is adopted by the uh, peraturan daerah or the kanun of the Aceh, that the criminal Islamic criminal law implement for the Muslim community in Aceh. However, this integration is not without challenges. The new KUHP also emphasized that customary offenses must not conflict with Pancasila, the 45 Constitution, human right, or general legal principles. In other words, customary law is respected as long doesn't violate universal values. The process of establishing binding customary regulation should actively involve customary institution and ensure legal clarity for the citizens. Reform of customary and religious law must work in synergy, but sources are part of the nation's rich legal heritage that must not be neglected, provided they are bridged with the universal principles of justice. Overall, we must continue to balance local values with universal human rights principles in the drafting of national legislation. Pancasila embodies the philosophy that humanity and social justice are the soul of the state. Therefore, both the legislative process and judicial practice must reflect values of the solidarity, respect for the local wisdoms, and the guarantee of the human right. As I have emphasized before, legal reform cannot rely solely on legislation. It also emerges from progressive judicial interpretation, civil society advocacy, and academic innovation. No single party holds a monopoly on the legal truths. The government's role is to orchestrate the various sources of the law, Western, Islamic, customary, and jurisprudence so that they all work synergy without neglecting one progressive of without neglecting one another. In building a living legal system, we should learn from successful international practices such as Germany, constitutional review, France codification, South Africa's recognition of living law grounded in human rights. The key point is that integrating human rights with the local values must form the foundation of the legal reform so that our law maintains strongly legitimacy in the eyes of the people. In the context of the legal reform, law faculties at the universities play a significant role, and it is very strategic. Universities must serve as laboratories of the legal thought. Academic needs to develop progressive ideas on justice, such as concept of restorative justice, progressive law, or new exclusive jurisprudence. Law school should also strengthen the legal clinics to assist vulnerable communities, as well as to conduct collaborative research with the NGOs and government on current issues such as the revision of the criminal code, maritime government as rightful practice, and decriminalization. Furthermore, collaborations with the international academic networks broaden perspective, which should then be absorbed and adopted to the international legal context. The academic community must be actively involved in lawmaking through policy studies and monitoring the implementation of legislation in the world. With the involvement of universities, egalitarian legal theory can be consolidated as a reference for the government's policy. As a professor, I firmly believe that the integrity of law students and lecturers is a guarantee for the sustainability of just and fair law enforcement in the country. Distinguished guests, ladies and gentlemen, let us realize the aspiration for the legal systems that people centered. We are determined to build a system of law that is fair, human, and society just. This means enforcing regulations with concern, ensure that the law protects the vulnerable, and holding the principles of universal humanity. As Professor Supomo reminded us that customary law is the essence of our legal identity. Let us use the cultural roots and aspiration of the people as driving force of reform. It is our collective responsibility, executive, legislative, judiciary, and academia to articulate Pancasila in every law and judicial decision. Indonesia needs legal policies. They are not static but dynamic and responsive to the demands of the times. I'm confident that if we work together, strengthen the integrity of judicial institutions, and open spaces for the public participation, this crisis of trust can be overcome. Legal reform is not a competition to produce more laws, but rather the development of an international ecology that makes norms work. The state formulates the laws, the courts interpret the law, the legal profession sets standards, academic test them, and society brings them to life. We need strong legislation, but we also need judges who are courage and argumentative. We need contractual and compound standards that lower transaction costs. We need academic writing that can access impact, not merely embrace problems. And we need space for customary law that is grounded in empirical needs, not just romanticized ideals. In conclusion, we should once again inspire ourselves with our national motto, unity in diversity. Let us unite in legal reform, prioritizing dialogue and wisdom so that the law truly becomes the champion of the justice. May Allah subhanahu wa ta'ala, God Almighty, always guide us in holding justice and standing on the side of the people. Thank you, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. We would like to invite Professor Dr. Yusril Iza Mahendra, SHMSJ, to be in a specified position for accepting a plaques from Universitas Andalas. And also we would like to invite Rector of Universitas Andalas, Dean of the Faculty of Law, and our keynote speakers to be in a specified position. Okay, we will take a photo with a plaques. Please stand by to the documentation. Okay, 1, 2, and 3. Okay, we take a picture again. 1, 2, and 3. Okay, the next session is a photo with a participant and Director Universitas Andalas, Dean of the Faculty of Law, Professor Dr. Yusril, and our keynote speaker, please to be in a specific position. And then to all audience, please rise. Okay, to all the participants, please be in the middle position to take a picture. Okay. With a formal pose, 1, 2, and 3. Okay, once again, 1, 2, and 3. Okay, thank you for all and please be seated. Okay, to all audience, please. Okay, the next photo with a Minangkabau hand sign. Okay, to all audience, please rise. Okay, to all audience, please rise. Okay, 1, 2, and 3. Okay, once again, 1, 2, and 3. Okay, thank you for all and to all audience, please be seated.
Okay, now, ladies and gentlemen, we will now take a few minutes before the event will resume. And once again, we want to thank you to Professor Dr. Yusril Iza Mahendra, SHMSJ, or in Minangkabau we have a sign which is Datuk Maharajo Palinduang, because they will come to Minangkabau and Ranah Minang and Universitas Andalas.
Okay, and also we would like to say thank you to coming from Andalas Law Conference 2025. Okay, and now, ladies and gentlemen, we will proceed to the keynote speech delivered by Professor Tim Lindsay from Melbourne Law School, Australia. To Professor Tim Lindsay, the stage is yours.
Good morning. Ladies and gentlemen, distinguished guests, our distinguished hosts as well, and of course, students of the university as well. I was told that I should begin my speech with a pantun, but unfortunately, I don't have those skills. So saya harus mohon maaf sebelumnya saya tidak bisa menyampaikan pantun. So today, I want to speak to you about rule of law, back to the future. At university, I studied law, of course, but I also studied history. And I apologize that I am going to inflict a lot of history on you this morning. The reason is, as I remember being told in my first history lecture that I attended in week 1 of my first year at university, when we talk about the past, we are always talking about the present too. When we talk about the past, we are always talking about the present. That did not make much sense then, but over the years, I realized the truth of it. To emphasize a different aspect of the same idea, as the philosopher George Santayana said, those who cannot remember the past are condemned to repeat it. Next slide, please. I'm going to come back to both these quotations later on, but for now I want to begin in the past when I was doing field work in Indonesia 3 decades, 27 years ago to be precise. Next slide, please. Indonesia was then one of a number of Asian countries that made a transition to a more democratic system in the years following the catastrophic Asian economic crisis that began in 1997. But Indonesia's transition was one of the most dramatic and it attracted global attention. Next slide, please. The transition began just 5 years after Francis Fukuyama published his 1992 book, The End of History and the First Man, which articulated his highly optimistic, and it turned out inaccurate, view that the patterns of politics, history, and economic development were converging on a universally accepted model that fused liberal democracy with neoliberal economics. But he was not alone in believing this. Next slide, please. The Asian economic crisis hit Indonesia harder than any other country, and it had exposed the corruption of Suharto's system and indeed the hidden bankruptcy of the entire New Order economy. It is often forgotten that in 1998, 80% of all financial institutions and 82% of all listed companies in Indonesia were insolvent. That is something that has never been repeated by any other country. But this insolvency also triggered the systemic collapse of political and social cohesion, as well as that of the economy. And it created a crisis that lasted years and at times seemed to threaten the territorial integrity of the nation, a phenomenon that is common to the end of authoritarian systems. This disaster also led to Indonesia falling into the inflexible and sometimes neo-colonial hands of the IMF. The reform demands that the IMF imposed on Indonesia through the loan bailout conditionality agreements closely reflected the new global political model Fukuyama and others had articulated: liberal democracy with neoliberal economics. And the two were, in theory, tied together by principles of governance drawn largely but not entirely from American and European traditions. Next slide, please. But I want to be clear that democratic and governance reforms were not alien and unwanted. Most of the reforms delivered under IMF conditionality already had a strong base of support in Indonesian civil society, intellectuals, and the new political leadership that was emerging from groups that had been linked to dissent under Suharto's new order. Many of these groups have been struggling for exactly this kind of change for many decades, sometimes with great courage and sophistication. The persistent assertion of rule of law and universal legal values by civil society activists under the New Order were among the reasons why the New Order authoritarian state and its core integralistic state ideology was so rapidly dismantled once Suharto resigned and activists claimed a voice in policy and lawmaking. Yes, civil society was a key driver of reformasi, but in fact, a widely based consensus for liberal democratic change emerged rapidly among Indonesians. In 1999, very few in the legislature or in the media or anywhere sought to defend the new order model or oppose liberal democratic notions of separation of powers and the universality of human rights, even though these were things that just a year or so earlier had been officially considered alien, Western, and un-Indonesian. This was in part because of global enthusiasm at the time for liberal democracy as the so-called end of history, but also the strength of the new emerging civil society leadership. But it was also because many of Suharto's old elite accepted that democratization had become inevitable and had to be supported if they were to have any chance of retaining privilege and power, as in fact many of them did. They accepted democracy for the time being as a necessary evil. The result was massive reform at breathtaking pace, effectively reinventing Indonesia's entire political and legal system. The initial chaos of post-Suharto reformasi was consolidated and focused by the constitutional amendment process that began in 1999 under Habibie. These amendments effectively reallocated the power of the state along liberal democratic lines. Next slide, please. In this way, the key features of Suharto's integralistic state, that is, political power concentrated in the hands of an unaccountable president and his inner circle, was dismantled. The four sweeping amendments to the 1945 Constitution that followed the crisis from 1999 through to 2002 did much more than amend the 1945 Constitution. In fact, they almost completely rewrote that Constitution. It is, I think, a great irony of Indonesian history that the amended 1945 Constitution is now much more like the rejected 1950 Liberal Democratic Constitution than the original manuscript of the 1945 version. So, to be specific, the democratic transition in Indonesia delivered by the amendments included, among other things, transitions from unlimited presidencies to presidential term limits, from appointed to directly elected presidents, eventually through legislation, from limited, restricted and closely managed sham or false elections to generally open and fair elections at multiple levels across the country, from subjugated courts under the authority of the Ministry of Judicial Affairs to formal separation of powers and judicial independence, from no judicial review to a constitutional court that could review national statutes for the first time in Indonesian history, from human rights being left to the government to decide. And let's be clear, Article 28 of the original version of the 1945 Constitution did not guarantee any rights. It just says freedoms of association and expression can be determined by statute. In other words, it allowed politicians to restrict rights as they wished. So a transition from that to clear and extensive human rights guarantees that were basically copied from the Universal Declaration of Human Rights. From crushing restrictions on civil society, especially unions, press and the NGOs, to implementing new guarantees of freedom of expression and association, and a transition from military-backed rule with serving army officers in every level of government, shadowing the civil bureaucracy down to village level, to the armed forces pushed back out of politics and into the barracks. Now, as I have said, these transitions were dramatic and they attracted the interests of lawyers, scholars, and politicians around the world. Indonesian law and politics, which had been for so long seen as frozen under the ice of the new order, suddenly became an exciting topic of study and research around the world. In fact, Indonesia began to be held up as a model for other countries that were yet to conform to the new, apparently inevitable idea of liberal democracy twinned with neoliberal economics. This was particularly true for Muslim societies around the world, who were exhorted to follow the example of Indonesia, the world's largest Muslim society. Unfortunately, very few were able to make that transition, let alone maintain it, as was demonstrated as the so-called Arab Spring so quickly failed. But it's important not to overstate what the transition to democracy achieved. It was complete in a normative constitutional sense by 2002, but it took another half decade for much of it to be implemented in a regulatory and institutional sense. The first direct elections of regional heads were held in 2005. The first direct presidential elections were not until 2009. And the general courts were not able to independently administer themselves under one roof, satu atap, until 2006. Some parts of the transition, for example, protection of rights, have never been fully achieved. Part of the reason for this inability to achieve the transition is that the old elite groups, politicians and oligarchs, began to work out how to play democratic politics and recapture power. And so, under the rule of President Jokowi, the process began to reverse. Under his rule, Indonesia saw a drift away from liberal democracy that was slow but steady and accelerated in his second term. A creeping return towards the authoritarian model of the new order. As Jokowi said at the time, our democracy has gone too far, and he set about winding it back. Next slide, please. Please go back, sorry. You've gone way ahead. Oh, that'll do. Okay, come back. Yep, thank you. All this took place against the background of a wider shift globally away from optimism about democracy that Fukuyama had articulated in the 1990s towards the far right instead, with authoritarianism mounting challenges to the liberal democratic model all around the world, from the US to Russia, India, Hungary, Italy, France, the Netherlands, among others. And of course, Indonesia has been no exception. In fact, it's fair to say that the decline of liberal democracy in Indonesia under Jokowi has now led Indonesia, like the United States, to a historical inflection point where the question of whether liberal democracy will survive intact may well be decided one way or another in the coming 4 years. Next slide, please. President Prabowo Subianto has made it very clear what his position is. Soon after election, he said, quote, democracy is really very, very tiring. Democracy is very messy and costly. And on its website, the political party Gerindra still has as its #1 mission statement a return to the Constitution of 1945, as stipulated on 18th of August. Mempertahankan kedaulatan dan tegaknya negara Kesatuan Republik Indonesia yang berdasarkan Pancasila dan Undang-Undang Dasar 1945 yang ditetapkan pada tanggal 18 Agustus. So, dislike of a Reformasi-era democracy was not unique to Jokowi or indeed to Gerindra. It seems to be shared by many politicians from many other parties, including PDIP and Golkar, which are, with Gerindra, the largest parties. Certainly, both PDIP leadership and senior Golkar figures have at different times spoken in favour of a return to the original manuscript of the 45 Constitution, although no one has yet made that proposal formal. Next slide. But let's be clear about what Gerindra's mission statement involves. If Indonesia did return to the original 1945 constitution, it would mean undoing most of the liberal democratic reforms introduced after Suharto. It would reverse the amendments that transform Indonesia from a military-backed authoritarian regime to an emerging democracy. It would reverse the changes that implemented separation of powers, independence of the judiciary, press freedom, and which sought to combat the corruption of the New Order period. Next slide, please. Let's be very specific about this. A return to the Naskah Asli would mean, that's the original manuscript of the Constitution, would mean no more presidential term limits, no more directly elected presidents, no more human rights guarantees, no more separation of powers, no more judicial independence, and the Constitutional Court would no longer exist. And so that would be the end of judicial review. So the undoing of the reforms of 1999 to 2002 is a chilling prospect. Although this is still only a mission statement, it's not a concrete proposal. However, in reality, the threat to democracy may be more immediate and perhaps more subtle. Even if the original version of the 45 Constitution is not revived, much of Indonesia's reformasi democratic system has already been weakened. The journey back to something like the original 45 Constitution and the new order seems already underway in any case. New slide, please. To explain this, I want to talk about three elements that form part of the foundation of the Orde Baru, although there are obviously others. Military domination of civilian life, lack of judicial independence, and absence of freedom of expression. These were core parts of Suharto's Orba. So, new slide, please. I'll come first to military domination of civilian life. The new TNI law, which allows civilian posts to be occupied by serving military members in 14 ministries or government agencies, increases the military retirement age. And this complements amendments to the civil service law, the RSN, that were already passed in October 2023 under Jokowi. Article 19 of that law allows active members of the army and police to occupy civilian positions. And Article 7(2)(b) of the new amended TNI law justifies expansion of military operations other than war, including allowing soldiers to undertake operations against perceived cyber threats. And these operations can be authorized directly by the president. And of course, the retirement age of TNI personnel can be extended. There were already many senior TNI personnel. Extending the retirement age means they have to have jobs, and to accommodate an oversupply of senior officers, the solution has been to increase regional commands, Kodam, which are going from 15 to 37. So these changes, can I have the next slide, please, are a creeping step backwards towards reinstituting the new order territorial system by which the army shadowed the civil administration across Indonesia. And of course, Dwi Fungsi, by which the army became a partner in power. This has not happened yet. Some officers have been appointed to civilian roles in the government. We have not seen this reach anything like the levels it did under Suharto. But the point is that these changes are now made possible in the future. And that is the concern. Next slide, please. The Constitutional Court law is one of the most amended laws in Indonesia. Politicians can't stop changing the law because they see the Constitutional Court as one of the only institutions remaining that can check and balance their power. The Constitutional Court has certainly had problems, including with its leaders, and some of those problems have been very serious. And it is certainly possible to criticize individual judgments that the court makes. You may not agree with them all. But the Constitutional Court has provided both Indonesia's first public forum for serious debate on the interpretation and application of the Constitution, and its first significant body of detailed and reasoned judgments. And it must be acknowledged that some of the judges of the Constitutional Court have made great efforts to create a new model of judicial decision-making and explain how liberal democracy should work in Indonesia. And some of those judges are still willing to bravely say no to bad laws, even laws that the government wants and regards as important. Judges still stand up and say no. And these are essential things if liberal democracy is to survive and flourish. And that is why the current bill to amend the Constitutional Court law again seems to be an attempt to undermine and weaken the court. Since the Constitutional Court was first set up, The President, the DPR, and the Supreme Court have been able to nominate 3 judges each. Under earlier versions of the law, judges could serve 2 5-year terms. Nominating institutions could reappoint the judges for a second 5-year term, or they could refuse to do so and sack them. In 2020, judicial terms were abolished and tenure was increased to a maximum of 15 years. The proposed amendments would reintroduce the 5-year terms. Like the original system, nominating institutions could refuse to give approval for judges to continue in office. This would mean that existing judges who have served for more than 5 years could be removed quickly. This has 3 major bad consequences. First, it allows government to stack the court with sympathetic judges, something we've seen happening around the world. Secondly, it puts dissenter judges who are willing to say no, at risk. And thirdly, it means other judges have a strong reason to approve bad laws, to keep their jobs, given the nominating institution can so easily remove them, as we saw with Justice Aswanto. So if these amendments pass, the second elements of Suharto's new order could well come back into place: a lack of real judicial independence and no effective check on the constitutionalism of laws passed. As we saw under the new order, a constitution loses legal authority if governments can pass laws that contradict the constitution without fear of annulment. Next slide, please. Proposed amendments to the broadcasting laws severely limit the scope for the media to perform its critical role of holding the government accountable. The new criminal code, which will come into effect next year, already prohibits criticism of government, reviving provisions in the old code that the Constitutional Court previously struck down. The proposed amendments to the broadcasting law go further by banning exclusive broadcasting of investigative journalist content. And it defines the term broadcast to include digital platforms. So this provision could stop investigative reporting in audiovisual formats, like Dirty Vote. This means that while journalists may be able to continue to produce print reports, broadcasters cannot broadcast them if this law is passed. This matters because Indonesians get their news online, not through the print. And broadcasters who breach the law can be prosecuted under this law. In other words, the potential reach of these provisions is vast. They could be used to stop the media and civil society from carrying out a fundamental role of holding the government to account. The new ban probably violates constitutional rights to freedom of expression and will almost certainly end up before the Constitutional Court. And the court has said it will decide petitions for review of the new criminal code after the code comes into force next year. So the integrity of the Constitutional Court and its ability to say no to government is critically important as these new laws come into place. If the court cannot say no, or at least soften these potentially devastating threats to media freedom, then a third element of Suharto's new order will be back in place: lack of press freedom, and thus the absence of government transparency and accountability. So, next slide, please. To conclude, these 3 repressive legislative changes and proposals, along with others I don't have time to discuss, such as the Ormas law and the KPK amendments, all of these seem to be steps back towards reinstating elements of the new order system. The effect would be to turn Indonesia back towards the authoritarian systems that emerged under the original 1945 constitution without needing to return back to the Naskah Asli, or the original version. And of course, another step in the undermining of democracy would be to end direct elections and end the 2-term limit on the presidency, all of which have been discussed by politicians. If that could be done, there will be no need to return to the original version of the 45 Constitution. The government's coalition now constitutes almost the entirety of the membership of the DPR, so it clearly would have the numbers in the MPR to make these kind of amendments to the constitution if it so wished. It hasn't done this yet. One reason for this that is usually given is that politicians are afraid to reopen the constitutional amendment process because they worry they will not be able to control that process once it is started. This is the Pandora's box argument. But that view may now be shifting. In the wake of the August protests this year, we have seen a major crackdown on civil society that has resulted in the arrests of almost 1,000 activists, and more importantly, the intimidation of many more. Certainly, politicians are going to be wary of provoking public protests again after August, but there is also the possibility that the combination of the government's domination of the coalition in the DPR and the chilling of civil society may make ruling politicians bold enough to make legal changes that will strengthen their position, if not now, then in the year ahead, when the government feels more secure. Legal and political change rarely moves in a straight line, direct and simple. It goes in fits and starts, attempts and failures, retreats and sidesteps, as politicians test power policies and ideas, look for legitimacy, retreat in the face of opposition, and find new ways to win. But in my view, the overall trend in Indonesia under Jokowi and now is clear. There is a move back to the future. Next slide. At the start of my presentation, I quoted George Santayana saying, "Those who cannot remember the past are condemned to repeat it." But American author Kurt Vonnegut has responded saying, "I got news for Mr. Santayana. We're doomed to repeat the past no matter what." Let us hope Vonnegut is wrong, at least in the case of Indonesia. Remembering what really happened in the past, whether it was 1945 or 1965 or 1998 or August, remembering what the new order was like and how it functioned is very important for making decisions today. Legal history matters. So in conclusion, if a decision is ever made to return to the original version of the 45 Constitution, Indonesia would certainly be going back to the future. The reformasi process finished a long time ago, maybe 20 years ago. But a return to that early version of the Constitution would mark the end of Indonesia's second and longest period of democracy. Next slide. I have argued today that the end does not have to come as a bang by a formal return to the 1945 Constitution. It can come as a whimper, less suddenly and more quietly. This is even more likely, that liberal democracy will end as a result of gradual erosion by creeping authoritarianism, with sequential legal changes building on each other to slowly eat away at the key pillars of legal democracy until there is not much left but a shell. Many things are necessary to defend liberal democracy and resist the possibility of a creeping return to traditions of integralistic authoritarianism. But three things are especially important. First, publicly discussing the dangers of a return to the new order model, maintaining a vigorous public discourse on constitutionalism and liberal democratic values, and understanding what the problems were with the new order system. Two, supporting and defending the integrity of the Constitutional Court. Without powers of enforcement, the court can only be effective if the government is willing to follow its rulings. The government usually does so, but the court must always walk a fine line between, on the one hand, upholding the Constitution in its amended form, and on the other, keeping the government sufficiently on side to ensure it follows the court's rulings. So public support for the court, especially when it is under attack from politicians, is crucial to the court's survival. But how to do this? How to support the court? History again suggests the answer, which is my third and final point. Supporting and encouraging civil society activism in the face of arrests, trials, and government hostility to enable the defence of, among others, human rights, especially freedom of expression and association, defending the separation of powers, judicial independence, and judicial review is critical. Civil society is is the key to the defence of the Constitutional Court, which is in turn the key to the defence of the liberal democratic system. And of course, the amended Constitution that enshrines those ideas. Thank you very much for your patience.
Thank you for Professor Tim Lindsay. And then we would like to invite to be in a specified position for accepting a plaques from Universitas Andalas. And now we would like to invite Dr. Nani Mulyati SHMCL from the Faculty of Law Universitas Andalas and also in a specified position to giving a plaques from Universitas Andalas to our keynote speakers. Okay, we will take a picture. Okay, 1, 2, and 3. Okay, the last session, we take a picture. Okay. Thank you for our keynote speaker and Dr. Nani Mulyati.
Okay, ladies and gentlemen, before we proceed to the first plenary session, allow me to take a moment to express our sincere appreciation to our sponsors and supporting partners who have made this first Andalas Law Conference possible. We would like to extend our gratitude to Equity, Lembaga Pengelola Dana Pendidikan atau LPDP, Auriga Nusantara, Yapika, and Dompet Duawa. Thank you very much for your continued support and contribution to this academic event. Your partnership truly helped advance the discussion and research on law reform and equitable law enforcement in Indonesia. Once again, thank you to all our partners and sponsors.
And now, ladies and gentlemen, we are delighted to begin our first plenary session of the first Andalas Law Conference. This session will be moderated by Dr. Nani Mulyati, SHMCL, from the Faculty of Law, Universitas Andalas. To Dr. Nani Mulyati, SHMCL, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, distinguished guests, esteemed colleagues, ladies and gentlemen. Allow me to extend our warmest welcome to all participants joining us here today at the first Andalas Law Conference hosted by the Faculty of Law Universitas Andalas. It is my great honor and privilege to serve as the moderator for panel session 1 with 4 incredible speakers from different backgrounds. Let us call to the stage the honor Dr. Prim Haryadi, SHMH. Profesor Simon Bat. Profesor Dr. Idewa Gede Palguna, SHMH. Mr. Rolly Francis Canlos Pioro, please come to the stage. Before we begin the presentations, allow me to briefly introduce the profiles of our distinguished speakers. First, the Honored Dr. Prim Haryadi SHMH is the Chief of the Criminal Chamber of the Supreme Court of the Republic of Indonesia. He earned his bachelor's and doctoral degrees in law from Universitas Andalas and his Master of Law from Universitas Indonesia. Throughout his distinguished judicial career, he has served in various key positions, including Justice of the Supreme Court, Director General of the General Judiciary Agency, and Chief Judge in several courts such as Jakarta Selatan, Denpasar, and Depok. Beyond the judiciary, he is actively involved in professional and alumni organizations, serving as chairman of IKAHI, PTWP, and IKFH UNAND. So he actually prominent alumni of Fakultas Hukum Universitas Andalas. Secondly, we have Professor Simon Bat. He is Professor of Indonesian Law at the Sydney Law School, University of Sydney, and one of the world's leading scholars on Indonesian constitutional and judicial systems. Fluent in Indonesian, can you please?
Terima kasih banyak.
He has advised numerous institutions, including the Australia-Indonesia Partnership for Justice, UNDP, and the International Commissions of Jurists. His extensive body of work includes influential books such as Judicial Dysfunction in Indonesia in 2023, Indonesian Law with Professor Tim Lindsay in 2018, and the forthcoming The Indonesian Constitutional Court Evolution of a Judicial Institution. Professor Bat has served as an expert witness on Indonesian law in courts across Australia, Asia, and Europe, and continues to contribute actively to academic, judicial, and policy reform dialogues on law and governance in Indonesia. Let's give a warm round of applause to Professor Simon Bat. Professor E. Dewa Gede Palguna is a professor of constitutional law at the Faculty of Law Udayana University, where he has been teaching since 1988. He served as the regional representative of Bali in the People's Consultative Assembly of the Republic of Indonesia, MPRRI, from 1999 to 2003, and played an active role in the amendment process of the 1945 constitutions as a member of the Ad Hoc Committee 1 of the MPR Working Body in 2000 until 2002. Professor Palguna was also appointed as a Justice of the Constitutional Court of Indonesia for 2 terms, in 2003 until 2008 and 2015 until 2020. Since 2023, he has served as the chairperson of the Honorary Council of the Constitutional Court of the Republic of Indonesia, MKMK. Let's give a warm round of applause to Professor E. Dewagede Palguna. And Mr. Rolly Francis Pioro is an environmental lawyer and law professor from the Philippines. He earned his bachelor's degree from the University of Pilipinas Diliman and his Juris Doctor as class of valedictorian from San Sebastian College Recoletos, where he later served as associate dean from 2018 until 2022. Currently, he heads the Direct Legal Services Division of the Legal Rights and Natural Resources Center, Kasamasa Kalikasan, Friends of the Earth, focusing on environmental and indigenous people's rights litigation. He has appeared in landmark environmental and human rights cases, including advocacy for victims of the Philippine War on Drugs and the legal defense of Senator Laila de Lima. Beyond his legal work, he is an avid mountaineer and former president of the UP Mountaineers, contributing to the Sierra Madre Nature Trail Conservation Project. So let's climb the mountain together and give round of applause to Mr. Rolly. Thank you very much, gentlemen, for joining us on the stage. Without further delay, let us begin our session. I would like to invite our first speaker, the Honor Dr. Prim Haryadi SHMH from the Supreme Court, to deliver his presentation. Yang Mulia Dr. Prim Haryadi, the floor is yours. Maybe we have 15 minutes. 15 minutes.
Oh, yeah. 10 minutes. Okay.
I have time 15 minutes. Maybe it's better for me to speak in Bahasa, ya, because I'm not confident in English, but I tried like do it. Good morning, distinguished guests, honorable speakers, ladies and gentlemen. We are especially privileged to be joined today by esteemed figures whose presence richly enrich our discussion. Allow me to respectfully acknowledge we don't have here rector, dean, and the other. Maybe Prof. Tim Lindsay from the University of Melbourne. And I would like to extend my respect, appreciation to all distinguished speakers, both from Indonesia and abroad. To entire academic community of the Faculty of Law, Andalas University, to all participants who have taken the time to attend and the organized committee whose dedication and hard work have made the event possible. Okay, we start with a history of SLAP, Strategic Lawsuit Against Public Participation. SLAP was first introduced by Pring and Cannon in 1988. We have definition here, SLAP. Next slide, because we have a bit time. Purpose of SLAP. SLAP is strategy to stop or punish citizens, arm the different public attention from public issue to private and personal issues, intended to harass, intimidate, divert attention, and weaken the resistance of members of the community. SLAP using the codes to silence public participation and freedom of expression. Next slide. Understanding anti-SLAP. Anti-SLAP is a legal protection mechanism or efforts aimed at preventing or stopping SLAP. Next. In 2014, Walhi recorded that 173 defenders were arrested, 7 were harassed, and 2 died. Between 2014 and until 2018, the Agrarian Reform Consortium records 940 farmers and activists criminalized. In 2019, ELSAM added that 128 individual and 50 community groups were victims of violence. Next. We have SLAP typology based on sector. I think next. International policy framework. We have Article 10 of the 1992 Rio Declaration. We have 1990 HR House Convention, Article 19 Universal Declaration of Human Rights. Next. Okay, next. Yeah. Obligation of judges in Indonesia who adjudicates environmental cases. Judges are required to identify or consider the age factor which contain good and healthy quality of the environment a part of human rights. Next. Form of anti-slap policies in civil cases according to Perma number 1, 2023. The first, the judge renders a decision on lawsuit that constitutes a slap by declaring the lawsuit inadmissible. Second, the judge ruled on the slap lawsuit by declaring the lawsuit dismissed. And the third, the judge may grant a counterclaim from the defendant who is sued in a slap case. Form of anti-slap policy in criminal case according to Perma number 1, 2023. The judge issued a ruling declaring the public prosecutor in the indictment inadmissible. And the second, the judge issued a ruling stating that the legal charges were dismissed. Next. Efforts by the Indonesian Supreme Court to improve the quality and capacity of judges. Environmental cases be handled by an environmental judge who has undergone environmental judge certification. As October 2025, there are 1,738 judges who have been assigned to courts throughout Indonesia. Now we have best practice cases in Indonesia, civil cases study. This is before 2009, environmental law. Before we have environmental law, case position PT Newmont versus Dr. Rick Norda. PT Newmont is a gold mining company sued Dr. Rick Norda, a lecturer at Samratulangi University, for her statement published in the Kompas, one of famous newspaper in Indonesia. In her opinion, Dr. Rick Norda states that the company's mining operations, particularly its mining waste, the caused Minamata disease among the local population and resulted in fatalities. Next. The case position, the plaintiff, Manado District Courts ordering Dr. Rignoda to pay compensation and issue an apology in a number of mass media outlets. The Manado High Court upheld the decision of the Manado District Court. So before we have environmental order, we have a decision from Manado District Court and Manado High Court. Supreme Court decision anti-SLAPP. About this case, the Supreme Court ultimately granted Dr. Rignoda appeal and overturns the previous decision of the District Court and High Courts. In this case, the activities of academic activities whose presents scientific analysis and opinions in the context of environmental advocacy cannot be criminally prosecuted or subject to civil lawsuit. Such actions are protected a public advocacy efforts. Even before anti-SLAPP regulation, we are especially established in positive law. Next. We have civil case study Cibinong District Courts. This is a new one. PT KLM versus Professor Dr. Insinyur Bambang Hero Saharjo and Mr. Professor Dr. Basuki Wasis. The case position, PT Kalimantan Lestari Mandiri sued the two academics from the Bogor Agricultural University, IPB, who had provided expert testimony in a case involving a peatland fire on PT KLM's plantation. Judge consideration, the expert testimony present at the trial is a form of the struggle for the right to a good and healthy environment as protected by Article 66 of Environmental Law. Next. Important notes on the Cibinong District Court in the civil courts. For the first time in Indonesia, an anti-SLAPP ruling was handed down through an interlocutory decision. The judge has taken a progressive stance. The judge provides early prevention against SLAPP attempts. Next. Through the anti-SLAPP mechanism, the courts not only enforce the law, but also protects freedom of expression and academic freedom. Next. Now we talk about criminal case study. In criminal case study, defendant Daniel Fritz Maurits Tangkilisan. He is an environmental activist who protects against pollution caused by the illegal shrimp farms in Karimun Jawa through posts on social media. His position, Daniel replied to one of the comments with the sentence, "The shrimp brains community enjoys free shrimp while being eaten by the farmers." The point is, the shrimp brains community is like the shrimp themselves. They are fed well, abundantly, and regularly. Jepara District Court ruled that Daniel sentenced to imprisoned and a fine. But Semarang High Court and the Supreme Court's judgment Daniel Fritz violated the Electronic Information and Transaction Law, but his actions were intended to protect a healthy and a good environment. He was finally released from all legal charges, or we say ontslag van rechtsvervolging. The other criminal case study, in 2020, resident of Kenanga Village, Sikh Neighborhood Association, we call Rukun Tetangga, RT, filed a class action lawsuit against the company for alleged environmental pollution. After the lawsuit was filed, they were reported by a resident for abuse of office and document forgery. Sungai Liat District Courts judgment 6 of them was found guilty and sentenced to 1 month in prison. But in Bangka High Court's decision, Bangka High Court overturns the district court's decision and a rule of their own which a decision of High Court decision of free from all legal claims on ontslag van alle rechtsvervolging. It is legal consideration the defendant's action constitutes community participation in struggle for a good and healthy environment. They must be protected and not criminalized for such activities. Last, anti-SLAPP exists to ensure that the voice of people defending nature are not silenced by power or capital. Judicial activism is the bridge between the letter of the law and the conscience of humanity. We have once our traditional as a wisdom of the Minang realms teacher. Alam takambang jadi guru. It means nature is our teacher. From the earth we learn fairness. From water we learn clarity. From the wind we learn coolness, and from fire we learn lights. I think that's all. Thank you very much.
Thank you very much, Pak Prim, for incredible presentation. And we realized from the cases that he explained to us that SLAPP being used to criminalize many activists. Next, we would like to call to the stage Professor Simon Bat. The time is yours. Thank you very much.
Halo. Good. Selamat pagi. Atau sudah siang ya? Ya. Terima kasih for inviting me to talk this morning sebagai speaker dalam panel yang begitu bagus. Di sini banyak hakim dan bagus. Yang ingin saya bahas hari ini adalah masalah putusan provisi di MK. Boleh? Oh iya. Boleh maju satu slide-nya. I begin with a quote from a human rights scholar in Canada, namanya Kent Roach, who has written about remedies or apa bahasa Indonesia-nya agak susah sebenarnya, remedies, apa yang dapat diperintah oleh pengadilan in in human rights cases. And I have translated this into Indonesian just so that you understand the beginning of my presentation, what I will talk about for Indonesia, for participants who maybe not able to understand English perfectly. So the quote is, masyarakat mengharapkan pengadilan untuk melindungi mereka dari kerugian langsung dan tak dapat diperbaiki yang tidak dapat sepenuhnya dipulihkan melalui ganti rugi atau upaya hukum lainnya setelah persidangan, setelah putusan sudah dijatuhkan. Pengadilan yang secara singkat menolak pemohonan upaya hukum sementara atau putusan provisi hanya sebagai masalah diskresi dan prosedur semata dapat gagal dalam fungsi paling mendasarnya untuk melindungi para pihak yang berperkara di pelanggaran hak asasi manusianya. So it is not too much of an exaggeration to say that interim remedies or putusan provisi are critical, sangat penting bagi the meaning of human rights and the judicial role in making human rights meaningful. Maju, please. The core of the problem that I want to discuss today is something that constitutional courts throughout the world face on a day-to-day basis. Sometimes an applicant with a very strong case will come to the court and say convincingly that their human rights are in jeopardy, in peril, and they seek protection from the court. But sometimes constitutional adjudication takes weeks or months or years. And by the time the court decides the application, the government may have taken the very action that the applicant asks the court to protect him or her or it from. And as a result, the applicant's constitutional rights might be damaged, perhaps permanently, perhaps in a way that cannot be restored. And so in many countries around the world, including in Indonesia, it's possible for applicants to ask the court for a temporary order or a putusan provisi. The order might be to prevent the application of the law that is being challenged, or it might be an order directing a public official or an institution to take particular action or not to take particular action, depending on what the human right is that is sought to be protected. Tolong maju satu. Now, sometimes, well, different courts around the world handle this problem in different ways. So there are many courts, I think, around the world that refuse to give a putusan provisi. They may argue, for example, that their function is only to perform abstract review, not to provide justice in concrete cases. Of course, the problem with this approach is that it risks making the court look weak and unable to provide any real constitutional protection. On the other extreme are courts that entertain injunction requests, not just protecting the applicants, but all of those to whom a law that is challenged might apply, and providing maximum potential protection to constitutional rights. I suppose most courts fall within the middle of these two extremes, and provide some type of putusan provisi or interim relief, but have lots of restrictions, impose lots of rules and tests in order to determine whether to grant a provisional decision. Lanjut. Oh, next one, I think. Oh no, back. Agak sulit saya nggak bisa lihat. Apa ya? Oh yeah. So what I want to do today is to examine how the Constitutional Court of Indonesia decides whether to give a provisional decision or not. And I think it's fair to say there are around 100 cases in which the Constitutional Court of Indonesia has written a little bit more than a few sentences about provisional decisions in their judgments. It's fair to say that in most cases, the vast majority of cases, the Constitutional Court has rejected an application for a provisional decision. As far as I know, it has only agreed to suspend the operation of a law or to make an order to a government official or institution in 3 cases since its establishment. And it did this for the first time in 2009, and I'll talk about that case later. From an outsider's perspective, reading these cases one by one, my impression is that sometimes the court is a little bit inconsistent in how it addresses these issues, whether it decides to issue a provisional decision or not. Sometimes it has said yes to applicants. It has ordered the president not to remove commissioners of the KPK, or it has prohibited the forced retirement of prosecutors in another case. I'll talk about these in a minute. But has not explained why, in very similar important cases, it has refused to give a putusan provisi. And that, I think, is the nub of what I want to talk about today. I won't talk today about requests for expedited hearings, which are another type of putusan provisi, or discuss cases involving electoral disputes or jurisdictional challenges. Those are other types of cases where the court is more willing, I think it's fair to say, to issue a putusan provisi. Now, there are a couple of main types of provisional applications, or provisional permohonan provisi yang diminta oleh para pihak atau pemohon in constitutional court cases. The first is the temporary suspension of the operation of the law that is being reviewed. So, for example, in some of the cases about the omnibus law, Undang-Undang Cipta Kerja, para pemohon have asked the court to prevent the job creation law being applied by the government until the court's final decision is made. But there are also a number of other types of cases where these types of requests have been made, particularly candidacy cases for elections. Candidates ask the court not to, or to prevent the application of an electoral law to prevent candidacy while the court is still deciding the case. And then there are many types of cases where applicants ask the court for particular orders directed at specific institutions or officials. So we have seen requests from applicants asking the court to order the DPR not to mengesahkan Perpu. We've seen requests for the court to order the president to stop the deliberation of regulations, or the government to stop or not make government regulations under a statute. There are many, many other examples that I could give. Lanjut, please. Now, as I've said, in most cases, the Constitutional Court has rejected the application. And there are several grounds that are often given as reasons for rejection. One is that the court only performs abstract review. It doesn't adjudicate concrete cases. And the court also says, in some cases, that because its decisions apply erga omnes, apply universally to all, it's not intended that its decisions apply to individual cases. Now, to me, at least, these two reasons contain a couple of fundamental logical problems. One is that to have standing to bring a claim, applicants must demonstrate that they have a constitutional right that has been damaged or is likely to be damaged by a particular law. They must show concrete personal harm. Yet, despite having shown that they have suffered this harm or are likely to suffer this harm, the court will then refuse to issue a provisional decision that may prevent harm, that very harm, from occurring to the applicants, pending the outcome of the court's decisions. So, to me, this is a difficult problem. In order to be able to bring a claim, an applicant must show concrete loss or potential loss. But then the court says, but there's nothing we can do about this until the final decision. The court also often mentions Article 58 of the Constitutional Court law when it rejects provisional decisions. That law says, so that provision says that legislation under review remains in effect until declared unconstitutional. Often in the same breath, the court points to Article 57 of the Constitutional Court law, which says essentially that its decisions operate only from the moment that the court hands down the decision. And so I think the implication here is that only after the final decision can any order be made or any application of the decision be felt by the applicants. But I don't think that Articles 57 and 58 restrict the court in the way that it says the provisions restricted. For example, I think there's no reason why the court could not convene to read a provisional decision and for them to make it binding after it's been read out. Decision here is not specified as a final decision. So it could refer to a provisional decision. So why can't the court issue a provisional decision that applies at the moment that that decision is read out? Another reason that the court has given is that the MCA law, the Constitutional Court law, doesn't specifically say that it can provide putusan provisi in constitutional review cases. But as I will show, there are cases where the court has done just this. And in fact, the court has made regulations that allow putusan provisi or putusan sela to be made. So there's no reason why this should prevent the court from issuing more provisional decisions. Next slide, please. So we have two examples. There are actually three, but I only have time to talk about two. And I've already discussed very briefly what these two cases are about. The first was case 133 of 2009. And this was a case involving two KPK commissioners who had been accused of a crime by police. And under the KPK law, this meant that they could be immediately suspended. And the Constitutional Court decided, in fact, that it would prevent their suspension pending the outcome of the final decision of the court. And the court gave a few reasons why. It said that the potential for constitutional damage was high in this case. It referred to the community's sense of justice. And it talked about there being irreparable harm. So once the commissioners were suspended or removed, it would be hard to restore them back to their original positions. Now, one of the interesting parts of this case, which I'll come back to in a minute, is that later cases have mentioned this case and said that there must be some kind of urgency, keadaan yang mendesak, to give a provisional decision. But in fact, in this decision, in 133/2009, the court did not mention urgency at all. The second case, as I mentioned earlier, this is case 70 of 2022. It was about the mandatory retirement of prosecutors. And to cut a long story short, the court again thought that there were really serious constitutional rights in peril in this case, and that it would be very difficult to restore prosecutors who had been forced to retire back into their positions. And so it also, in this case, decided to award a provisional decision to prevent the mandatory retirement of prosecutors under this law. Next slide, please. So, as I mentioned before, one of the criticisms that I could make about these cases is the fact that urgency was not established as a requirement in case or decision 133 of 2009. But subsequent decisions of the MK have said that there must be a keadaan yang mendesak atau urgency berdasarkan putusan 133 tersebut, walaupun tidak disebut dalam perkara atau putusan yang bersangkutan. The other issue that I would raise here is the concept of tidak dapat dipulihkan, tidak dapat be restored to the original position. So in both the KPK Commissioner and the JAXA retirement cases, the court says, well, if we don't give a provisional decision now, by the time the court hands down its final decision, the applicants will have suffered loss that cannot be reversed. But I find that a very difficult concept in these two cases. It would have been quite easy to restore the two commissioners to their positions in the KPK case. And it would have been quite easy to restore the retired JAXA into their positions if the court decided that their mandatory retirement was unconstitutional. Compare this with decision 21 of 2008 about the death penalty in narcotics cases. And in that case, the court said, well, we can't give a provisional decision, but surely a death penalty case is the very definition of an irremediably damaged constitutional right. Someone could be executed pending the final outcome of the case, and you can't restore them, you can't bring them back to life. So what should the Constitutional Court do? Maybe maju dua slide. Well, I suppose it can look to other courts and international tribunals. Now, in Canada, in South Africa, in South Korea, and other places, I think it's fair to say that courts might be more willing to provide provisional decisions to protect applicants whose constitutional rights might be damaged before a final decision of the court. But there are a number of considerations that these courts use that might be considered by the Constitutional Court if it wants to go down this path. One is the prospect of success. So in both the KPK Commissioner and the JAXA retirement cases that I mentioned, the court seemed to think it was not particularly relevant whether it was likely that the applicants would be successful at the end in the final decision. And many other courts around the world that allow provisional decisions, this is a key factor. And the more likely it is that, the stronger the case, I suppose, is a good way of putting it. At the beginning, the more likely that a provisional decision will be given in the end. So that's one aspect that might be taken into account. So I know it's a very short amount of time. It's quite a complex and very technical area of constitutional law. But personally, in my view, I think it's something that the Constitutional Court could consider into the future, particularly if it's trying to provide stronger protection for constitutional rights in the future. Thank you.
Thank you very much, Professor Simon Bat, analyzing Indonesian Constitutional Court's reluctance to grant interim relief, despite its role in preventing immediate rights violations. Thank you very much. Next, we would like to call to the stage Professor Idewa Gede Palguna. The floor is yours. Please give a round of applause to Professor Palguna.
Okay, thank you very much. Firstly, I would like to thank the organizing committee for inviting me in this important occasion. Although it is not my first visit to Andalas University, I think Andalas University feels like home to me. Yeah. Okay, I would like to make effective of 15 minutes given by the moderator to present my short presentations about the. Would you please? Yeah. Yeah. I was asked by the committee to talk about a constitutional complaint for the protection of marginalized communities. I think it is my fourth or fifth presentation about constitutional complaint. And now it's become so popular in Indonesia since I wrote my PhD dissertation in 2011 in Universitas Indonesia on the issue. And every time, we are talking about constitutional complaint, and especially especially about constitutional complaint and about constitutional court in general, I always remember a joke launched by a prominent Poland lawyer, Ms. Ewa Letowska, who once tells an anecdote about a hungry traveler entering a restaurant in a former authoritarian country in Eastern Europe. The traveler says, "May I have pork chop, please? Boleh saya minta sepotong daging?" And the waiter said, "I don't have any." "But there is in the menu." "Yes, but I don't have any." "What about meatballs?" "Bagaimana dengan bakso?" "I don't have either." "Okay, what about liver then?" "No," said the waiters. And the hungry traveler said, "Am I reading the menu, or our constitution? It is kind of dark jokes. Okay, that's why I think constitutional complaint always important to be discussed in Indonesia, especially. So let's reflect. Uh, um, yeah, what has been happening in Indonesia lately? Land grabbing, conflict in Kinipan. Maybe our colleagues, Pak Yanja Arizona, knows well about this case. Rempang, Wadas, and now Batur in my homeland. About Danau Batur, there was an investor who wished to introduce what is a kind of cruise, yeah, a tourist cruise in our Danau Batur, Batur Lake, which is considered spiritually protected in our religious system in Bali. What um, really what makes those really matters for us is the question is what enables yeah, land grabbing, especially the agrarian conflicts or cases prohibiting establishment of places for worship of minority groups and inadequate accessibility of people with disabilities. It's not only a matter of unfair regulations, but it also a matter of how the law is implemented by the state officials. So the question is, what enables this case for being happening? What enables some of these events to occur in the unequal proposition of society, which naturally and structurally marginalize, marginalizes, I mean, the marginalized groups. So let's take a look at the reality of citizens and equal protection as a general preconditions in Indonesia at the time being. For the purpose of this conference, I would like to give understanding of marginalized community refers to individuals or groups to the margin of the periphery of society where they have limited access to resources, opportunities, and participation in decision-making processes. Marginalized groups often face social exclusion, stigma, and discrimination. Marginalization affects various social groups, including, this is just to name examples, racial and ethnic minorities, indigenous peoples, persons with disabilities, even immigrants, refugees, and religious minorities. Marginalized groups experience barriers to employment, education, healthcare, housing, political representations, leading to social, economic, and other judicial marginalizations. This is my experience whilst when I served as Justice of the Constitutional Court, uh, whether in the first period and second period, 2015 until 2020. So that's why when we are, it remains important, even urgent, to talk about constitutional complaint, the topic we are discussing today. Yeah. So why can such condition in a country, even in Indonesia, who claims, yeah, to be a democratic state. Yeah. The assumptions that law is a product of the ruling class, which is synonymous with the dominant class, means that considerations for minority groups is not given equal value. This has led to the creation of marginalized groups. If we give a brief analysis of the situations. So constitutional democratic states often guarantees formal equality in terms of rights and freedoms, but however, in reality it shows that formal equality alone is not enough, as Professor Simon Butt just presented. And marginalized groups often experience substantial inequality. So, what is the implication for the role of the state in the context of it is quite theoretical. I would like to ask the audience to discuss this situation from a Rawlsian context. If we look the situation from the Rawlsian context, the state must design policies and institutions that ensure that any inequality that occurs is justifiable according to rules. That is, only if it benefits those who are most marginalized. The state should not assume that formal opportunities alone are sufficient, but attention must be must also be focused on the real conditions that hinder marginalized groups in order to achieve their equality of opportunity. The state, according to rules, must actively intervene in the basic structure, either political and economic institutions, that create or perpetuate marginalization. For example, through redistributive mechanism, special assistance, and recognitions of marginalized identities and situations. So, how can these situations be redesigned and institutionalized in the context of the rule of law in Indonesia? That is our question to be discussed today, and maybe in the long term. Let's first we revisit the existence of the Constitutional Court. You know, the existence of the Constitutional Court is based on the idea, in short, based on the idea to uphold the principle of constitutional democratic states. That's the main idea why we established the Constitutional Court in Indonesia following the fall of President Soeharto during the reform movement in 1998, and followed by the amendment of our constitution, the Constitution of 1945, that now has already been more than 25 years. Okay, we already have Constitutional Court. We already have the power of the Constitutional Court to annul laws that infringe or against the Constitution, infringe citizen constitutional rights and against the constitutions. But is it enough? No, it is not enough at all. We need that the state exactly, absolutely guarantee the fundamental rights or the constitutional rights of its citizens to the maximum extent. That's why we need constitutional complaint mechanism to be adopted in our national legal system, especially within the power of the constitutional court or the authority of the constitutional court. Because uh, when we combine ideally the maximum protections of citizen constitutional rights according to the ideal when we establish the constitutional court, if we can combine the the judicial review mechanism and the constitutional complaint mechanism. Why? Because when we are talking about the unconstitutionality of law, the answer is judicial review. But when we are talking about the absence of public officials acts or the negligence of public official acts that makes the infringement of the citizen constitutional rights, the answer is constitutional complaint. Yeah. Even there is no violations, there is no norms of law that violates constitution, but when state officials act and that act infringe constitutional rights of citizens of the country, or state officials which are supposed to act, but they don't taken any step, while that kind of negligence finally infringe the citizens' constitutional rights, it can only be fulfilled with the mechanisms of constitutional complaints. I think that is the basic idea of my presentation, sir. So, I don't think I have exceed the 15 minutes given by the moderator. Thank you very much.
Thank you very much, Prof. Palguna. Highlights the persistent inequality forced by marginalized groups in Indonesia despite constitutional guarantees of equality and justice. Thank you very much. Last but not least, let's ask call to the stage Mr. Rolly Francis Pure. Please give a round of applause to Mr. Rolly.
Good morning, everyone. I'm Rolly from the Philippines. First, my utmost gratitude to the Indonesian people, to the organizers, to the University of Andalas. I hope I can return the gracious hospitality when you are in Manila. My role this morning is to discuss the protection of the remaining natural forests in national and international legal perspectives. I will be talking from a perspective of an environmental lawyer who walks with the communities. I will use the lens of these communities, especially of the indigenous communities. So before I proceed, let me start with the organizational profile of the Legal Rights and Natural Resources Center. We are based in Manila, in Quezon City, and our center's advocacy focuses on the recognition and protection of the rights of indigenous peoples and upland rural poor communities to land and environment, especially with the advent of the climate change crisis. For more than 3 decades, our center has been in the forefront of the battle of our environmental advocacy in the Philippines. Okay. No. I am tasked to present the presentation from the Philippine perspective and hopefully a glimpse of few international strategies. I have divided my presentation into 4 parts. First, I will give a forest situationer, then the frameworks in the Philippines which we use to protect our forests, and then some of the policies to protect those people that protect our forests, and a glimpse of the international legal approaches that we adopt in the center in helping these communities. Uh, The next slide will provide the status of the Philippine forests. As you can see, our country has 30 million hectares territory, but right now we only have 7 million hectares of forest. That's only a fourth of our national territory. This is a far cry from the 1930s, wherein we have 17 million hectares of forest. No. And according to studies, we again lost a total of 1.42 million hectares of tree forests from 2001 to 2022. And that's just a glimpse. If you are going to use some of the standards, some of the indices, the Philippines will always be at the top rock when it comes to vulnerability. No, but when it comes to performance in protecting the forest and the people that protect the forest, we are very sluggish. We are in the bottom ranks. This is some of the indices. According to the Climate Risk Index, we are ranked 17 in the world's most affected by extreme weather events. But according to the Yale University, we are 97th in protecting our forests. It's a very far cry. Now, the news would tell us that in the past 16 years, we are number one, most at risk country for the 16th straight year, especially with the Typhoon Yolanda. We are facing an average of 26 typhoons every year. When I am hearing the presentations of all the speakers, actually I am wondering if I am actually in Manila because we are sharing many similar stories, especially when Professor Tim told that we're going back to the future. No? Most of the problems that being faced by the Philippines happened in the Marcos presidency dictatorship in the 1970s to 1980s. But surprise, our president now is again a Marcos. So maybe we are advanced in going back to the future, Professor Tim. No? And anyway, no? Despite being most at risk, we share, unfortunately, we have the recognition of being the most dangerous in Asia for the green activists. We are ranked fourth in the world, especially with the number of killings of forest defenders. So you can see the disparity. The most vulnerable, but the most dangerous area for a forest defender. Now, to give a glimpse of the Southeast Asian region, it's actually a mirror of the Philippines. We are a major deforestation hotspot with high biodiversity loss. No? Due to interest of time, I will be skipping some of the slides. According to the ASEAN Center for Biodiversity, our region loses an average of 800,000 hectares of forest each year. And I think this annual loss of forest for the region is larger than the area of Padang. No? So, according to the 24 study, this Mekong region lost nearly 1 million hectares of tree cover, or about one-fourth of which was primary forest. And the usual suspects are the usual commercial culprits. The drivers of forest loss, like in the Philippines, similar in Southeast Asia, is the agribusiness, mining, weak land tenure systems, aggravated by the threats to the indigenous communities. I am sure that similar in Indonesia, most of the forests overlaps with the communities of indigenous peoples. And in the Philippines, the indigenous communities serve as the vanguards of these remaining forests for us. No? In this graph, you would see that Indonesia is actually better than the Philippines. We rank second last with regard to the forest cover. The last would be Singapore. But considering the land area, the landscape, and being a first world state, Philippines is actually the last in the region. If you would just consider the special status of Singapore. So what's the point of this? No, being the last, as stated earlier by Professor Tim, we must learn from experience. But what I would like to share is that we can also learn from other people's experience. especially with our neighbors' experience, in the hope that we can spare the heartbreaks and all the struggles that we are facing right now. So the issues and challenges based on that situation, according to our government, one of the main reason for this forest situation in the Philippines is this one. The going back, uh, we have an outdated and contradicting forest policies, making ineffective the management of our forests. As you can see, this is our graph from 1934. We have 17 million hectares of forest. Then it drastically went down during these years. No? Steadily, there was a bump in the 1988 to 2003, but we are saying that this is just an aberration because of an error in the reporting. No? Right now, as stated earlier, we have only one-fourth of our remaining land territory that has forest cover. Another reason would be the undefined boundaries, which hamper the conservation of forest land and national parks. Year by year, we are increasing the numbers of our critically endangered plants and animals. Now, these are some of our critically endangered plants. Another reason would be the incoherence in our disaster risk management that hinders accountability. No, we are trying to catching up, but still based on the World Risk Index, we are still the most exposed when it comes to climate risk. With the environmental defenders, these are the issues that we are facing, no, especially with the communities that we are helping. We we have the distortion of the concept of human rights, public vilification, red tagging. I don't think we have the similar problem, but this is a very prevalent problem in the Philippines. Profiling, surveillance, militarization, weaponization of the law, shrinking civic space, and the climate of impunity. No. With that challenges, we're doing some catching up. The protection of the forest in the Philippines can be subdivided into four efforts. First would be the designation. Next would be the regulatory compliance. The third would be the push for public participation. And the fourth would be the legal remedies being pushed by the Philippine Supreme Court. In the designation component, let me share that we have several laws, ideal laws, that identify areas to be protected areas. This is under our National Integrated Protected Area System Act. We also identify forest reserves. We also identify critical habitats through our Wildlife Resource and Conservation Act. Our local government units, through the local government code, have the power to designate local conservation areas protection forests. Based on our law, we have a very powerful tools to protect this environment. However, implementation and execution is a different animal for us. Na? For regulatory compliance, we have numerous laws that requires environmental protection, foremost of which is this one, the requirement of environmental impact statement. It requires all environmentally critical projects to submit an environmental statements, impact statements. These are some of the laws. No? For the public participation, we also have very beautiful laws that mandates public consultation and public participation. In our constitution, we have the right to petition our government for redress and grievance and the right of the people to information on matters of public concern. We are given that the duty actually, not just the right, but the duty to protect the environment, to participate in these kinds of activities. In in the late 1990s, we finally passed our Indigenous Peoples' Rights Act. This is a recognition of the rights of our indigenous communities. It's a very powerful tool. As stated earlier, many of our remaining forests overlaps with these ancestral domains. We also have, as stated earlier, the Philippine Environmental Impact System. It's a very powerful tool. and the prior public consultations under the local government code. No? W- Despite these laws, we have some issues, especially with the implementation. Despite our right to information on matters of public concern, currently, our Department of Environment and Natural Resources prohibits us to access the environmental impact statements of all environmental projects, making us blind to all the alleged environmental impacts of whatever environmental projects in the Philippines. The free prior informed consent process for the indigenous communities, it requires all projects to obtain first approval of the affected indigenous communities. But most of the times, the process is being done in an atmosphere of fear and intimidation, making it a not so genuine process for the communities. As stated earlier, this is a very powerful tool. It now gives certificates of ancestral domain title to all the indigenous communities. No? Finally, they can obtain a certificate that the certain land of area belongs to their communities. No? And with that, it gives them the right to be consulted in all activities that can be done within their ancestral domain. No? Okay. Recently, the center has been in partnership with several indigenous communities. We are promoting this one, the Indigenous Peoples Biodiversity Strategy in Action Plan. This is the first indigenous-led national strategy in the Philippines where the indigenous communities themselves would identify the threats and the ideal strategies that they think would be proper for their communities. Of course, this should be in sync and in agreement with our national laws. With the passing of this Indigenous People Rights Act in the late 1990s, the Supreme Court of Philippines have now several jurisprudence that supports the Indigenous Peoples Rights Act. In the 1970s, we have the Philippine Forestry Code, one provision of which is the prohibition of the cutting of native trees in our forests. In a recent jurisprudence, the Supreme Court acknowledges that there's a discrepancy and there's a conflict with some of indigenous communities who use these indigenous native trees in their traditions, especially in the making of their communities. And in a recent jurisprudence, our Supreme Court held the indigenous communities are exempt in certain provisions of the forestry code, especially when it comes to the protection of their ancestral domain. One of the efforts of our government is the called National Greening Project. It's a very ambitious project which aims to plant 1.5 billion trees over 1.5 million hectares. Unfortunately, based on our assessment and our government's assessment, this has been a dismal failure as it only achieved 177,000 hectares, missing the target by 88%. Also, one of the issues that been raised is that the project actually focused on monocrop plantations, including bamboo, mango, and mahogany. Some of these are invasive species in the Philippines. So it really, instead of helping the reforestation efforts, it's now a problem in the Philippines, especially with the plantation of mahoganies in several areas in the Philippines. When I entered the university, it reminds me of the University of the Philippines in Los Baños. We have a very hilly campus in the Los Baños, but most of the surrounding areas are now planted by mahoganies because of this greening project. And they're now trying to catching up to rectify that project. So on our legal reforms, we are pushing for this one as part of our catching up. We need to enact a sustainable forest management program. We need a national land use law. Unfortunately, until now, we don't have this law where the government will identify the boundaries for every land use in the country. We need to delineate specific limits of our forest lands, update our mining laws, amend our Wildlife Resource Conservation and Protection Act, and monitor the implementation of climate policies and projects. So that's our assignments in the Philippines. Now I am going to the special legal remedies that we as practitioners in the Philippines, as environmental lawyers, are now using. Maybe we can learn some from these legal remedies, special legal remedies. To summarize them, we have, as discussed earlier by Professor, we also have provisions against strategic lawsuit against public participation. We have the writ of kalikasan. This is special order. Kalikasan means environment in the Philippine language. So this is a writ of environment. We also have the writ of continuing mandamus, the environmental protection orders, and the preliminary injunction. No? These all special remedies came to order in 2010 when the Supreme Court finally promulgated our distinct rules of procedure for environmental cases. It's a good news for all environmental lawyers during that time because prior to the rules of procedure for environmental cases, all environmental cases use the ordinary rules for civil actions. No? And with the rules of procedure for environmental cases, there are very bright provisions that we are now taking advantage of. No? These are some of those beautiful provisions of our environmental rules. First, it offers a broad scope. It covers a lot of environmental laws in the Philippines. It tries to expedite the proceedings by prohibiting certain dilatory pleadings. It also adopts a continuous trial, a shorter time frames for proceedings. No, and it prohibits the issuance of temporary restraining order and preliminary injunction unless it is the Philippine Supreme Court who will enjoin the cases. For practitioners like me, what I really like most is this one, the waiver of filing fees. One of the major deterrents in environmental cases in the Philippines is the charging of the courts for filing fees. In the average, we charge 2% of the damage that needs to be filed in the court. So assuming that we need to file 100 million peso suit, it will require us a 2 million pesos, no? Or a 500 around $100,000 just to file that environmental case. But with the rules of procedure, it's being deferred or it's being actually waived. So that's very crucial for us, encouraging many communities to file more environmental cases. And we now adopt the precautionary principle, which states that in case there is doubt, there's a scientific evidence proving that this can be done, and another scientific evidence stating that project could cause environmental court, this principle requires all our courts to lean on the side of caution. So we really like this precautionary principle. And these special civil actions, let me walk you through with some of these provisions in our environmental rules. We have the same SLAP concept. It is basically a harassment suit. It masquerades as ordinary lawsuits, but the purpose is really to scare, to have the chilling effect, to silence all the dissenters. In the Philippines, there's a provisions that the plaintiff must prove the suit is not a slap within 5 days. And it would be done in a summary way, and the party who seeks the dismissal would only need a substantial evidence to prove that this is actually a slap. No. And the party being faced with slap may be awarded with damages. No. This is some of the examples of the slap cases being filed in the Philippines. The prominent is the libel case. Libel is actually a defamation suit, especially the cyber libel, the posts online, especially on Facebook. Many mining companies and other extractive companies would file a defamation suit to these citizens who filed an environmental post on the environment, especially when it comes to the effects that they're experiencing in their communities. So there are a lot of experience It's, it's increasing year by year. One of the specific case that I've handled is this one, the Masungi Forest Rangers in the province of Rizal. They're actually internationally acclaimed forest rangers for the Masungi Reserve. But because of the mining tenements and other entities who wants to encroach in the forest, they are now facing frustrated murders, grave assaults, and other criminal charges. We have already dismissed some of them, but the charges still continue. We invoke SLAP in some of these cases. This one is also in Romblon, one of the remaining Virgin Islands we considered in the Philippines, but it's now being uh, entertained, being explored by many mining companies, even in the Muslim Mindanao. I am sharing this story in some of the professors yesterday. Muslim Mindanao used to be a war zone for the past 2 or 3 decades. And ironically, the forests in the Muslim Mindanao were preserved because of the war. Now that the peace situation is getting better, the mining companies are now going there. The extractive industries are now going there. So the development, the so-called development for these extractive industries are now exploring the virgin forests of the Muslim Mindanao. No? Slap cases can also be done in administrative charges. Is one example. A mayor from Palawan who canceled the business permit of mining companies were slapped with administrative suits, which resulted in her suspension as a mayor, no, as a town leader in the province of Palawan. One earlier, it was shared the case of Professor Rignaldo, if I heard it correctly. We have this jurisprudence, the FCF Minerals Corporation in 2021. In an unfortunate turn of events, it was a mining company who invoked the SLAP provision. A certain mining company, the FCF Minerals, was complained by the communities for their environmental effects in Nueva Vizcaya. Later on, the communities, due to confluence of factors, withdrew the complaint. But the mining company filed a SLAP suit. They stated that the unjustified filing of the environmental suit cost them legal fees amounting to 10 million pesos or $200,000. They're demanding that the communities pay that legal costs. So they're the one who invoked the SLAP suit. Fortunately, the Philippine Supreme Court stated that the remedy of SLAP cannot be indiscriminately invoked by any defendant in an environmental case. The Supreme Court held that it may only be invoked by individuals who became target of litigation due to their environmental advocacy. It is not a remedy of powerful corporations to stifle the actions of ordinary citizens who seek to make them accountable. The Supreme Court said, no, to allow the complaint of the mining company would entertain the main evil that the SLAP suit, no, is targeting, is actually trying to avoid. So this is one of our recent jurisprudence. It clarifies, it states that the mining companies cannot use the SLAP provision. No. There's still few more challenges we're pushing, that the conviction rate be used as a key performance indicator for prosecutors, police, and our environment and natural resources department. The context for this is that the mere filing of complaint is already tagged as an accomplishment, regardless of what would be the outcome of the case. No? And most of the conviction rate for environmental cases is very, very low. Very, very low. So we're pushing that the conviction rate should be high, no? To encourage the filing of only the legitimate complaints. Sadly, the SLAP rules only apply when the case is already in court. But on the prosecutor level, it still cannot be used. We are pushing also for the decriminalization of defamation that is now the rampant uh, vehicle being used by extractive industries in filing environmental cases against environmental defenders. So that's our slab. Going now to the special writs, we have this, we call the writ of amparo. It's a Spanish word. If I understand it correctly, it's to take care of someone. So it's a special remedy if you are now facing a threat to your life, liberty, and security, especially to cover extralegal killings and enforce disappearances or threats thereof. This is very important for us, especially that, as stated earlier, we are the most dangerous area to be an environmental defender. No? One of the phenomenon in the Philippines is red tagging. It's our version of McCarthyism, wherein people will be tagged as members of the left political spectrum. It is a form of harassment and intimidation. And according to the Nations High Commissioner for Human Rights, labeling certain groups of persons as red oftentimes comes with frequent surveillance and even resulting to some deaths. Unfortunately, for it's worse for our women activists because red tagging would result with rape and other forms of sexual assault, even rape threats. The most ultimate effect is the chilling effect on freedom of expression, causing the communities to be silent in their struggles, in their environmental struggles. Fortunately, recently in 2023, the Supreme Court of the Philippines ruled that red tagging is already sufficient to justify the issuance of a writ of amparo. The Supreme Court said no, that the person need not wait for the real abduction or actual killing to be done before he can or she can avail the writ of amparo. So writ of amparo is very powerful for us because it can order any individual, including government and private individuals, to desist in any conduct that may be perceived to be a threat to these defenders. We also have this habeas data. No? It's a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by unlawful act or omission. This is especially invoked in cases of privacy violations. No? The beauty of the habeas data and the writ of amparo is the speedy nature that it gives to the litigants. When we use our ordinary rules, it will usually take 2 to 3 or 4 months before the court may even hear the case. But in these special writs, the courts are required to immediately issue the writ, and the respondents are required to comment and to report to the court within 5 days. Within 5 days from the issuance of the writ, within 5 days from the filing. So this is a very speedy remedy that we use to protect our environmental defenders. We also, as stated earlier, we have this new special writs, the writ of environment, we call it the writ of kalikasan, and the writ of continuing mandamus. Continuing mandamus is a special remedy issued by our courts to compel government offices to perform their duty when there is an unlawful neglect or unlawful exclusion of another from the use of enjoyment of such right in both instances. Unlike in our ordinary writs, the continuing mandamus, as adopted in Indian jurisprudence, the party must ensure that the dispositive portion, the judgment, would be done and would continuously report until the outcome that must be achieved is 100% achieved. No? That's the beauty of continuing mandamus. We also like this special writs considering this one. This special writs relax the locus standi. In our ordinary cases, you need to be a real party in interest. But for these special writs, even a people's organization can file on behalf of the communities. So this is being exploited by civil society organizations in the Philippines. We can file it. Even the communities are afraid to do so. No? As stated earlier, these writs also mandated the exemption from the payment of docket fees. This is really a very helpful provision in our rules of procedure for environmental cases. The rules also allow us to go directly to the Supreme Court. In our jurisdiction, we apply the doctrine of hierarchy of courts that all issues must first be filed in the first level courts. But when we talk to environmental cases, the special rules allow us to go directly to the Supreme Court, especially if the magnitude of threat or damage already covers two or more provinces. So we can go directly to the Supreme Court. No? So this is just some of the legal strategies internationally. We have the Asian Strategic Plan for Action for Forestry. We can also use the United Nations Strategic Plan for Forests, no? The Convention on Biological Diversity, which recognizes indigenous people roles. No? And this one, we always invoke this one, the Kunming Montreal Global Biodiversity Framework, which targets to protect high biodiversity areas at the same time integrating indigenous and traditional territories in these efforts. No? So I will end my presentation despite the daunting challenges and the not so bright situation with this quote, one of my favorite quotes, that to be truly radical is to make hope possible rather than despair convincing. I hope I have shared something meaningful from our experience that we can use here in Indonesia. Thank you. Maraming salamat.
Thank you so much, Mr. Raleigh. Such an incredible presentation discussing the alarming state of forests lost in Philippines and Southeast Asia. Actually, we only have small time and strict schedule, so we will only open one person that can ask question. And I would like you to state your name and affiliation and mention which speaker your question is directed to. Please, one person from in front row, can committee help me to give the, oh, you can just go to the center of the room. We have mic in the middle of the room. This is my student, my master's student.
Tes, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
I guess afternoon. I would like to send my gratitude to all the presenters, to all the narrators that all given the materials so insightful for all of us today. And I would like to give in two questions, especially in these sessions. The first question is to Mr. Palguna, and the second one is for all of the speakers generally. So the first question is for Mr. Palguna. I've read an article that stated that the idea of the constitutional complaint is already being brought to the discussion of the amendment of the constitutions, but being withdrawn by the House of the Representative because a lot of concerns. What I want to ask is it really difficult for Indonesia to bring constitutional complaint into practice, or is it really determined by the political will or political power at the time? And from your perspective, what is the most ideal conceptualizations to bring the constitutional complaint to the Indonesian legal system practice? And the second one is regarding, we are talking about a lot of environmental legal issues here, SLAPs, anti-SLAPs, and also indigenous people rights on the environment. The question is, in modern era, we need to make the balance between economics and also the protections of the nature and also the people. How we can integrate it, a model of solutions that can bring an equilibrium approaches into the economic and also the protections of environment. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Faras. I will give this to Prof. Palguna first and then to all the speakers. And please also give some closing remarks before we close our session. Please, Prof. Palguna.
Oh yeah. Thank you very much. to make it short, I think it is, yeah, it is not, to me, it is not really difficult to absorb or to adopt a constitutional complaint mechanism to our legal system, especially to the to become the one of the authority of the constitutional court, because academically speaking, it's all theoretically speaking, it's include in the term of a constitutional review. But different is when we are talking about the constitutional review consists or, or covers both judicial review and constitutional complaints. So what we really need to do is just to amend not uh, our constitution, but just our constitutional law on constitutional court, especially the meaning of the constitutional review or judicial review, by extending the interpretation of constitutional review so as to include the constitutional complaint. But as you mentioned, um, the political will, it's always be the case, will always be the case for the decisions. I think that's my sort response to the question. Thank you very much. Oh yeah, my closing remarks is I think uh, when we are talking about the law enforcement in Indonesia, now we need uh, to make the what is we need to make sure that we have endurance uh, on the side of civil societies, especially to quote unquote to pressure the government, especially the political powers within the state, to really consider the need of our people. Steps like making film of dirty votes, just to name an example, is important to ensure that that our needs, that the people needs, will always be heard by the political decision makers. Thank you very much.
Thank you very much, Prof. Falguna. Next, I would like to invite Mr. Rolly to give closing remarks and also respond to Farah's question.
Regarding the question of balancing the environmental issues, environmental protection and economic development, no, it's always been a struggle anywhere you go, no, which will be prioritized, like the environment or the economy, no. But one of the principles in environmental law that we always anchors our argument is the sustainable development. It's the principle that says that the current generation should have the ability to meet its current demand without compromising that of the future generations. So the development concept should now be leaning towards this concept, the sustainable development, and finally drop the idea that development only pertains to economic development. There are new human indices that provides for the measurement of development, not only through the GDP, gross domestic product, but one of my favorites indices is the World Happiness Report. You use development, you measure development through the lens of your people, through the lens of the well-being of people. If we can do that, no, there would always be a balance of the environmental protection and development in its newest concept. No? I hope that would be all. Again, thank you for inviting here. We're hoping for more collaboration and partnerships in the future. Thank you.
Thank you very much, Mr. Rolly. Next, I would like to invite Pak Prim.
Okay, I tried to answer the question. So I think between development and environmental, we have online, inline, I mean, inline, because our government needs money to build our country. But sometimes we have to think about the future, a life of future. So I think the environmental is one of can makes our future more better. That's all. Thank you.
Thank you very much, Yang Mulia Dr. Prim Haryadi.
Thank,
Please, Prof. Simon.
thank
Back.
you. I wish Prof. Palguna was still a judge, because then he could issue a provisional decision to order us all to have lunch, but also to prevent environmental destruction. Yeah, so that is my final comment. Thank you.
Thank you very much. With that, we conclude panel session 1 of the first Andalas Law Conference. Please join me in giving a warm round of applause to all our distinguished speakers. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much for our esteemed speaker and moderator for the engaging discussion. Now, we invite Dr. Charles Simabura SHMH as the head of the committee to present plaques to our speakers and moderator. We would like to invite to all of our speakers and moderator to be in the specified position for giving a plaques from Universitas Andalas. And then we will take a photo with plaques. There is our speaker, which is Dr. Prim Haryadi SHMH from Supreme Court of Justice. Then also Professor Simon Butt from University of Sydney, Professor Dr. Idewa Gede Palguna SHMH from Faculty of Law Udayana University, and Roli Franciscan Las Peoro San Sebastian College of Law. And also our beautiful moderator, Ibu Dr. Nani Mulyati SHMCL. Okay, first for the plaques, we would like to take a photo in 3, 2, 1. Okay, maybe we can to do this in once again in 3. Okay, 6. Now the second plaque is we would like to take a photo in 3, 2, and 1. Okay. Okay, the third plaque is we would like to take a photo in 3, 2, and 1. Okay. Take a photo in 3, 2, and 1. Okay, thank you so much for all of our speakers. Let's give them a applause. Also the certificate for sure. Also, don't forget to our moderator. Okay. Okay, we would like to take a photo in 3, 2, and 1. Okay, maybe we can to do the next session with the participant to take a photo. Oh, okay, enough. Okay. Thank you so much, Dr. Charles, and all the speakers, also the moderator. And to all the audience, please stay in the position.
Okay, ladies and gentlemen, it is now a break time and we will reconvene at 1:30 p.m. for the second plenary session. Thank you. See you soon and Assalamualaikum warahmatullahi wabarakatuh. wabarakatuh.
Okay, welcome back everyone. We will now begin the second plenary session moderated by Mr. Ferry Amsari SHMHLLM from the Faculty of Law Universitas Andalas. To Mr. Ferry, the stage is yours.
Committee just gave me two tasks. First, asking you to still open your eyes because this the tough time for still on uh, to this event. And the second one, I would like to invite several speakers uh, to coming to the stage. First, I would like to asking Professor Christy Warren and Bill Sweeney, Professor Ahmad Hidayat Buang, and also my friend, my colleague, Uni Nur Sarifah. Please take a seat. This seat is not belong to Jokowi, so whenever you feel free to take a seat. So before we asking all the speaker present their paper or PowerPoint, I would like to introduce all of them. The unique things actually, all the speakers, two coming from Asia, Malaysia and Indonesia, and two, and not two, one as a Western country, America, and another one, not Asia, not also Western country, half and half, Australia, our close friend in Australia. I would like to introduce first Uni Sarifa, Nur Sarifa, atau, or we can call her Uni Ipeh. Uni is a term in Minang. She actually working on Auriga Nusantara, a kind of NGOs working on environmental law issue, not only protection the environmental, but also talking about indigenous people and so on and so on. I'm part of her institution. Issue. And also Bill Sweeney. We actually met up in Australia. He is actually the professor in Australia Catholic University, not only as a professor, but also human rights activist. So we will discuss a lot the relation between environmental issue with the human rights things issue. Also, my own professor coming from far, far away from US with 2 delays, Professor Christy Warren. I want to introduce a lot of things regarding her issue, but I will explain a short things that she did in the past. She actually involved in 25 constitution post-conflict in several countries in the world. She also involved in Supreme Court as a chief of expert for the Supreme Court Chief Justice in US and many others, also very close with us in Andalas University. Yeah, several friends of her coming to this event also. And she will discuss about the perspective on how the state working in marginal people things in Indonesia. Yeah, kind of. And my new friend, Professor Ahmad Hidayat Buang, discussed about zakat law. Is a very important issue in Indonesia, Prof. Ahmad Buang, because not only that kind of zakat used for marginalized people, but also political things in Indonesia. So it seems a lot of relationship things on your issue, and you will present that things, and we will start to give a time to Uni Ipe. Time is yours. You can go there. Yeah. Please giving applause.
Okay, good afternoon, distinguished speakers, and also ladies and gentlemen. Uh, Thank you for the opportunity that has been given to Auriga to attend here in the international seminar in Andalas. Our presentation's title is Guardian Under Pressure, Repression, Protection, and the Pursuit of Ecological Justice. We use the guardian here as a synonym of environmental defenders. I start this presentation with unhappy condition due to the data that we collect for the 1 year after the Prabowo Gibran has been elected. Next page, please. Here are the condition of the threats to the environmental defenders in Indonesia. I disclaimer here, the statistic data here potentially has not shows the fact because the unreported cases out there can be more than what we collect here, because often the environmental defenders as the victims not report to the enforcement, so it has not been collected as the reported cases. For the 1 year after the Prabowo Gibran, as we see, the total of cases to the environmental defenders is 20 cases, with the victims more than 100 people. This amount happens only in 1 year. If we compare to the previous regime under Jokowi, the amount of the victims and also of the cases nearly to the data that we collect, but it happens in 10 years. I don't mention that the previous regime is better than now, but it is alarm to us because only in 1 year, the victims and also the case increase significant. The categories of attacks, next page please. The most attacks
is judicial harassment. We also include the SLAP, strategic lawsuit against public participations, include in this group, judicial harassment, and the intimidation, and also physical threats, and the worst is killing, with 2 victims in 2 cases. Next page, please. Here are the spread of the cases. As we can see, the cases happen from Sumatra and also in the Papua, and the concentrations usually happens in region with extractive industry, because as we know, the environmental defenders struggling for their land and for their rights, facing with the government program. Next page, please. North Sumatra, the victims is the most, and also in the East Nusa Tenggara, as the geothermal project, as we can see, the struggling of the environmental defenders in the geothermal project, and also in Celebes with the nickel industry, shows significant cases. Next. The sectors most involved in the conflicts: mining and energy, it requires most victims. Continue with the forestry sector, and also environmental, and then plantation, and the last is the agrarian. We also collect the corporation that indicate their activity to threat the environmental defenders. Here are the corporations: mining and energy corporations, looks like can to use the physical or maybe non-physical violence to the environmental defenders to silence the activity of the struggling of the rights. Next page, please. We try to draw the concept or the work of thinking of the environmental defenders. We put on the center. The threat to the environmental defenders happens because the root cause of the problems is not solved by the government. We can see the symptoms with the land grabbing, with neglecting of indigenous people's rights, foul lawmaking process, and pitting civilians against one to another, and then involvement of the security and defense forces. The root cause itself is because the agrarian disputes and the extractive business model that chosen by the government is violence with the principle of the FPIC and also the other principle of the human rights. It caused the structural victimization, according to the Ejat Fatah and also the Wolflet and Moby in 1994. The structural victimizations tends to be done by the authorities by using their powerful to violence the people, the indigenous people, the environmental defenders, the academics, and also to the NGOs, and so on. The threats to the environmental defenders most often doing by the SLAP, and we counter the threats with the anti-SLAP or the anti-strategic lawsuit against public participations. We can see the role of environmental defenders itself is not only by the environmental defenders itself, like indigenous people, to prevent their rights, their land, and then they become the direct victims of the policy. But also, there is a kind of group of people, of environmental defenders, that also suffer for the non-direct violence, such as the expert of opinions, as we can see Bambang Hero and also Basuki Wasis, who has been sued because of their opinions in the court, which is the expert opinions itself grouping as a scientific evidence because their opinions categorized as scientific evidence to the court. That's why the anti-SLAP itself should be maybe, sorry, not should be, but maybe can be guaranteed by the policies itself and also the judicial activism. The judicial activism is one of the issue that I want to explain furthermore, and also for the scientific evidence that provided by expert opinions or expert, which is in this case, in this moment, we want to show you that the expert opinions can also be severed by the CSO, such as Auriga. Okay, next page, please. We can pass this page. Yeah, judicial activism. Judicial activism is essential to protect environmental defenders and ensure the environmental justice. For the environmental cases, the judicial activism is significant because environmental cases intersect with human rights issues. And as Mr. Yusril Iza mentioned this morning, law often lags behind the social development. And the last, environmental litigation is inherently complex because it involves capital-driven economic intersects and also overlaps with criminal, civil, and administration law sector. That's why the judicial activism itself is significant to the protection of the not only the environmental but also the environmental defenders. This morning, Mr. Prim from the Supreme Court also mentioned about the judicial activism. As we can see, he's one of the judges that released one of environmental defender in North Sumatra, Sorbatua Sialagan. The Supreme Court released Sorbatua because the agrarian conflict should be finished first in civil court, not directly to the approach of criminal law enforcement. That's why, in the case of Sorbatua Sialagan, based on the Supreme Court decision, should be released, and then the court decision itself seems like a judicial activism that can develop the environmental defender law enforcement. Here, next page, please. Here I want to share to you the judicial activism in responding to SLAP lawsuit. First, in constitutional court decision, criminal law is inappropriate amid legal uncertainty over forest status. That's why agrarian conflict must be resolved through civil procedures to confirm land and indigenous rights. This decision in line with the Supreme Court decision that has been released by the Pak Prim Haryadi. The two cases, I mean the one and two, is the similar judicial activism opinion. And also we can see the Semarang High Court decisions regarding to the Daniel Fritz Tinkilisan, who has been released because he is categorized an environmental defender. And the last, the Cibinong District Court decision also stop or refuse to examine the legal lawsuit by the corporation to the expert from IPB, Prof. Bambang Hero, and also Basuki Wasis, because their testimony in front of the court is categorized as environmental defender activities. So the four of the decisions is part of examples of how judicial activism can contribute to protect the environmental defenders. Next, please. And for the NGOs itself, we not only doing advocacy, but also collect for the data and information through the process which with accountable way to share to the public that can be used to the law enforcement process. Why scientific evidence? Because complexity of environmental litigations requires scientific data and evidence. And this data or this evidence can be provided not just by the academic, but also from the organizations that focus on that issue, such as organization in environmental issue, as well as Auriga. The scientific evidence categorized as the
other evidence in criminal procedures law, and which is formed by the expert and then published with the kind of document, and that's why the opinions or the data or the informations provided by the organizations can be categorized as the expert as the scientific evidence. Next page, please. Yeah. Scientific evidence defined as explanation of the relationship between two or more components or elements within the environment presented in written form by an expert based on the result of research of scientific knowledge, with or without oral explanation before a court. The requirement of the scientific evidence itself, one is first is validity, and also the reliability and the objectivity. After this, I want to show you a video about Map Biomass Indonesia, a platform that has been developed by Auriga Nusantara. We hope that this output can be support as an option of the scientific evidence that can be used to the legal enforcement, particularly in environmental cases. Please, video 1 about the profile of
Map Biomass Indonesia merupakan jaringan kolaboratif dari organisasi non-pemerintah atau NGO, lembaga penelitian, perguruan tinggi, dan pengembang teknologi yang mempromosikan dan membangun data tutupan dan penggunaan lahan di wilayah tropis dan subtropis lainnya. Map Biomass berkomitmen untuk terus mengembangkan metodologi, data, tools, dan informasi untuk mendukung konservasi sumber daya alam dan pembangunan berkelanjutan. Produk inti dari Map Biomass adalah seri tutupan lahan disertai dengan analisis transisinya, yaitu perbandingan antara jenis atau kelas tutupan lahan dari tahun per tahun atau periode tahun yang bersangkutan, serta dilengkapi dengan analisis statistiknya. Di Indonesia, analisis ini dimulai dari 1990 sampai dengan tahun berjalan pada koleksi 4. Data ini sudah mencakup periode 35 tahun terakhir, yaitu 90 sampai 2024. Di luar land use dan land cover tersebut, Map Biomass juga memiliki inisiatif lainnya seperti Map Biomass Alerta dan Map Biomass Fire. Map Biomass Alerta lebih fokus kepada memvalidasi alert deforestasi dan menyajikannya ke publik dalam bentuk laporan yang bisa diakses secara bebas dan dilakukan analisis dengan melihat di mana deforestasi itu terjadi. Sementara untuk Fire lebih mengedepankan informasi mengenai area terbakar, baik periode tahunan, bulanan, atau akumulasi dari periode yang diinginkan, termasuk frekuensi kebakaran. Seperti Indonesia, kebakaran lahan dan kebakaran hutan seringkali terjadi. Informasi mengenai frekuensi kebakaran menjadi penting untuk melihat potensial atau daerah yang terus-menerus mengalami kebakaran hutan dan lahan. Map Biomass memiliki 4 fitur utama dalam hal pengembangan metodologi. Pertama, disajikan secara historical dari wilayah kajian tutupan lahan, kemudian dianalisis piksel demi piksel, dan klasifikasi dilakukan berbasis artificial intelligence, dalam hal ini pengembangan machine learning dan deep learning. Kemudian mengedepankan kerja kolaboratif yang diproses berbasis cloud computing. Mengandalkan metodologi tersebut, setiap tahunnya koleksi mat biomas akan diupdate baik penambahan periode serta penambahan kelas dan detail-detail lainnya, termasuk meningkatkan hasil dari akurasinya. Ya, strategi pembangunan setiap koleksi mat biomas Indonesia dimulai dari membangun mosaik disertai dengan parameter spektral yang akan digunakan pada tahap selanjutnya adalah melakukan klasifikasi dan kemudian melakukan penghilangan noise melalui proses filter spasial dan penerapan filter temporal. Setelah itu, semua data kemudian diintegrasikan menjadi satu peta yang berisi dengan kelas tutupan lahan sepanjang tahun periode analisis. Ya, setelah diintegrasikan, data kemudian dikalkulasi secara statistik untuk menghitung bagaimana transisi dari setiap kelas, setiap tahun, atau antar periode yang diinginkan. Dari hasil ini, kemudian kembali dilakukan filter spasial untuk menghilangkan noise dari transisi tersebut. Dan selanjutnya ketika data sudah bersih dari noise, dilakukan kalkulasi statistik untuk setiap kelas dan setiap tahun. Dan terakhir, dilakukan pengujian akurasi dari versi peta final di setiap kelas, di setiap tahun sepanjang periode pemetaan. Ya, setelah dilakukan kalkulasi statistik, kemudian dilakukan uji akurasi, data final kemudian sebagai tahap akhir siap untuk dipublikasikan. Mulai dari Sumatera, Kalimantan, Sulawesi, Kepulauan Maluku, Papua, Jawa, Bali, dan Kepulauan Nusa Tenggara. Masing-masing region memetakan 5 kelas dasar meliputi hutan alam, kemudian vegetasi alami bukan hutan, pertanian secara umum, non-vegetasi, dan wilayah perairan. Sementara tema yang lebih detail atau biasanya kami sebut sebagai sub-level dari tema dasar itu terdiri dari perkebunan sawit, pulp and paper, sawah, kemudian tambang, permukiman, aquaculture atau tambak, dan yang terakhir kami juga memetakan hutan rawa gambut.
Initiative to present alternative scientific evidence provided by the Auriga as a NGO. Thank you.
Thank you. One of environmental defender is actually indigenous people. And indigenous people, they have customary law. So I try very hard to link any issue. So Professor Warren will discuss about how we can use customary law to protect the idea to reform the law. So please, to Professor Warren, present her presentation around 15 to 20 minutes.
I will be fast.
Thank you.
So is my PowerPoint teed up? I guess while it's getting ready, I just want to say that it is such an honor for me to be back here at Andalas University. I think I've been here twice now, and the first time was 7 or 8 years ago. And the only reason that I came is that my very best student I've ever had, Ferry, I'm sorry, invited me after he graduated. You all should be very proud to have him associated with this university because he made a very big impression at William and Mary Law School in the United States, which is the oldest law school in the United States, very prestigious. And he was the top student. And I also want to say that it's a real honor for me to be in this room with so many experts in the field of Indonesian law. That is not me. I have used the works of these people. I've read them, I've cited to them in my own work, and I learn from them myself. but I am not an expert in Indonesian law. My field is in post-conflict reconstruction and post-conflict justice and comparative constitutional law. So I think my talk is going to be a little bit different than the other ones you've heard today. What I'm going to try and do is put customary law in a context, both globally, in terms of countries that use and have constitutional law, in terms of constitutionalization of indigenous customary law, and then why it is so important coming out of conflict, but not only conflict, out of colonization. And so I'm hoping that you can then take your own knowledge of Indonesian law and put it into the framework that I am giving you. So the question I'm asking is customary law valid or viable or possible as a path to legal reform in Indonesia? So, oops. I have to learn how to, there, whoops. Let me learn how to use this clicker here. There. So I don't know if you can see the data on this table. This is a table of global legal systems, and it's taken from the University of Ottawa in Canada. You can easily find it through Google. The name of the website is Jury Globe, like Jury Global, but it has a lot of different diagrams and statistics about the percentages of people who live under various legal systems in the world. And this is important. I want to show you the percentage of people in the world that live under civil law, European law. This is not common law like Australia or the United States or the UK, but under civil law is extremely high around the world. It is almost 64% of the world lives under civil law. You can see at the bottom the solid red. Those are that is the percentage of people who live today in a pure civil law system. But the crosshatch, the mixed section on top there, is the percentage of people who live in a mixed system of civil law and some other system. And that is directly the product of colonization. So when you're looking at customary law and you're looking at legal systems around the world, you must keep in mind the impact that colonization had, because the biggest tool that was used other than force during colonial movements was that people took their law with them, whether they were coming from France or Italy or the US or wherever, and they wanted to implant their own legal system as a tool of domination. And that is why I equate post-colonization with post-conflict. So for the purposes of this lecture here, the next most commonly used legal system around the world in yellow is customary law. And that is very surprising to a lot of people. The fact that so many people live under under customary law today. So you can see also it is in place only in part because, again, of colonization. So as you can see from the data here, 28% of the world's population lives in a mixed legal system of civil law and customary law. That is the result of colonization. 20.21% of the world's population lives in mixed systems of common law, Islamic law, and customary law, which is the result of a common law country taking their legal system abroad and introducing it either by force or power or whatever in another legal system around the world. And then mixed system of civil law, Islamic law, and customary law, 3.68%. So you can see that I'm sorry, I still have jet lag, I'm sorry. Customary law is still tremendously, hugely important in most of the countries around the world. So when you're thinking about how to move forward and what role customary law will have in Indonesia, there are so many lessons that can be learned from other countries, both in your own region and in Africa, in the Middle East, in Latin America, from people who are struggling to discover, to find out what role customary law can have in a modern legal system side by side with state law. So there's a lot of information to be learned. So the bottom black bullet point you can see here, the percentage of total populations in the world living either in a pure customary law system or a mixed system is almost 57%. More than half of the world lives in some form of a customary law system. And that represents almost more than 6.5 billion people. You know, so sometimes, again, I work in, most of my work is done in countries that are coming out of conflict and how to put a legal system back together again. But just knowing that you are not alone in the world and that there are 6.5 billion people that are going through this same exercise should be comforting to you and make you perhaps reach out and ask for lessons learned from these countries. This is a quick timeline. I keep forgetting that I'm going to show you here. Whoops. Okay, this is just a timeline to show you how old customary law is. It is the oldest legal system in the world. Before any other legal system was born, customary law existed because it was the way that people decided to live according to their own values and their own rules. So this is a timeline, and this flat surface here shows customary law in place all over the world. And I'm not going to go into too much detail with this, but the oldest legal system, one of them is the Talmudic legal system, the Jewish legal system that was born at the time of Moses, when Moses went up to Mount Sinai and he came back with the 10 Commandments. But it's very old, but not as old as customary law. This is the birth of the Islamic legal system. I teach a course in Islamic law, and it starts, of course, at the time that the Prophet Muhammad received the Quran from the angel Gabriel. That was the birth of the Islamic legal system. Again, very important. It's old, but not as old as customary law. This is the birth here in purple of the civil law system that was born back in Rome when Rome was very important in terms globally of politics. This is the common law system, which is the youngest legal system in the world. And I show this slide to my students to introduce humility to them because in the US, we teach US common law. That is it. We don't teach comparative law. We don't teach other legal systems. And very often, students graduate from US law schools and they feel like common law is the most important thing in the world, but it is the youngest and the smallest legal system in the entire world. And then we have here Asian legal traditions. Which have an overlay. But the point of this is you should be able to tell both through the last slide, which shows the percentage of people living with customary law, and this, which shows that it is the oldest legal system in the world. There is a lot of pushback um, um, in countries where constitutional reform is going on, and people, indigenous people in particular, but not only indigenous people, are trying to seek recognition and empowerment of customary law. And they're getting pushback from governments that feel threatened that customary law challenges their political sovereignty and their legal sovereignty. And also people who do not believe that customary law is a real legal system, that it is just something that's old fashioned, it's archaic, it's not written down, and it should not count as much as state law. Those are arguments that you find if you are an advocate for strengthening customary law. So some of the issues that come up here, these are a group of Tibetans who also live in Tibet under a customary legal system. These are some of the issues that come up when you're thinking about and analyzing and advocating for customary law, the sources of law and the values and the benefits. So, customary law lives in close harmony with the earth. And we'll talk about contemporary uses in a minute. This is why it is so valuable in terms of environmental law, because historically, all the way back to the beginning of this legal system, it has always valued the earth and care for the earth. Issues that are relevant to the community. I was reading, for example, the most recent Human Rights Watch reports for Indonesia for the past few years, and a lot of them have to do with criminal justice issues, detention, punishment, sentencing, arrests, those kinds of things. And customary law has a very interesting, different approach to criminal justice issues than more modern legal systems have, which is customary law views a crime as an injury to the community and also an indication that something in the community went wrong so that this person ended up committing a crime. So, customary law brings together members of the community, members of the family, the victim, the victim's family, the perpetrator, and they engage in what is called a sentencing circle where everybody provides their input about what happened here, what went wrong, whether it was drugs, whether it was theft, whether it was a battery, bodily injury. And the crime is discussed by the sentencing circle, and the remedies are decided by the entire group altogether. And there is enforcement, and there are remedies that are individual to the particular situation that arose. But the enforcement is that the community has participated in coming up with the answer and also the remedy here. So it's used very commonly, including in the United States. In some of our northern states, customary law is used in criminal justice proceedings, and various states, including Minnesota, the Supreme Court has held that this is a valid use of law and it will be enforced by the courts. All right, so characteristics of customary law. You probably already know most of the time it's oral. It emphasizes intergenerational equities. And again, this is terrifically important when you're thinking about land ownership and land law and environmental issues, because very common in customary land or customary law communities, outright complete ownership is not permitted. You are allowed to use land during your lifetime if the community agrees. You are not allowed to harm the land. You are not allowed to destroy the land because you have to preserve it for the use of your children and your grandchildren and people who are not yet born in your community. So the concept of intergenerational equities spreads out the benefits of land and environmental issues among different generations. So the goals are harmony with nature, again, very useful for environmental issues, reconciliation, and that again is criminal justice issues. The goal is not retribution, it is reconciliation and restoration. You probably have heard about restorative justice. So it's putting the community back together again instead of punishing someone and throwing them in jail. All right, some of the benefits with customary law, it has legitimacy with local communities. And I wrote down this quote that I think it was the minister who gave this quote during his presentation this morning. Customary law is the soul of Indonesian law. And that is true not only in Indonesia, it is true because it's the people's law and it is the oldest form of law. And the source is of the people. There's better access to justice. It's not as expensive and there are fewer barriers. And the customary law houses typically are much, much more common around the country so that people, women who have children, the disabled, everyone can get there more easily, does not have to transfer to the or transport to the capital of a country. So I just want to give you also constitutional recognition data a little bit. You might be surprised that the International Union for Conservation of Nature and Natural Resources, this is an environmental group, has done a comprehensive study on constitutionalization of customary law. You can find it online through Google. And they found that under 190 constitutions that exist in the world today, 115 of them mention, protect, identify, or establish a mechanism for implementing customary law. I mean, think about that number. And that gives a very effective pushback if your government is saying that customary law is outdated or it's backward or it's not as modern as state law. All right. Contemporary uses, and I've talked about a couple of them. Why is this useful? We've talked today, a number of speakers have talked about the rights of Indigenous people to enjoy the environment, to benefit from customary law, and to practice under their own legal system. But I have another perspective too, which is there are tremendous benefits that flow. There is wisdom that comes from customary law. And that wisdom, it's important to protect. So we see this in the United States in the United States in areas that have been overfished. Historically, indigenous communities know that if you overfish an area for many, many years in a row, the fish will run out, right? If you deforest areas of the land where the trees take 100, maybe 200 years to grow, you are going to end up with no trees. And indigenous people communities know how to rotate crops, to rotate fishing sites, to rotate forestation, to protect the environment. And in my experience, there's not enough respect for the wisdom that comes from indigenous legal systems. So it's not just a matter of the right of indigenous people, that's very important too, but it's also a matter of having their wisdom respected and used to solve contemporary problems that we have today. So that's with respect to land ownership, environmental issues, criminal justice, intellectual property. Intellectual property is a big, big topic in indigenous communities, especially in Latin America, where there are natural healing remedies that indigenous communities have known about for generations from the beginning of time, using plants and and vines and maybe even some of the wildlife in the jungle area of the Amazon, and you have that indigenous knowledge being stolen very often now because there's more of an emphasis these days on using natural remedies. So customary law is very important in terms of protecting the right of indigenous people to their own intellectual property. And then protection of cultural heritage too. Items that are, excuse me, collected and put in museums where they have religious and ritual significance to local communities. So coming out of conflict and colonization, you can see customary law represents a path back to a country's original goals and values before invasion by foreign forces. So this is a way of recapturing the soul of indigenous people through recognition and respect for customary law. This happens all over the world. I cannot even begin to tell you every single time a country emerges from conflict or colonization, there is a movement to go back to find what was theirs before the foreign influencers came in, all right, including with their legal system. However, there's a whole phenomenon that you may know something about. I don't know whether this happened with the Dutch or the Japanese in Indonesia, but it happened in the Middle East. When a foreign country comes in and introduces forcibly, usually, their own legal system, they push to the side the indigenous legal system, whether that was Islamic law, whether that was customary law, or whether that was something else. And they do it through the mechanism of repugnancy clauses. That is, the colonizers say that they will allow aspects of customary law or Islamic law to be used as long as those aspects are not repugnant to them, the colonizers. So there's a whole history of original law, indigenous law, that is recaptured by people coming out of conflict or escaping colonization. And then transitional justice. I'm almost at the end here. Transitional justice is a process of recovering from the conflict, reconciliation within the community. And the most effective processes of transitional justice, you may have studied this from South Africa or Rwanda, Cambodia. Myanmar will have to go through one of these, but local customary practices are the most effective way to build a lasting peace coming out of conflict and to reconcile communities with each other in a way that state law has proven to be very ineffective. So these are some of the hurdles that you face with customary law. It may not be recognized within a constitution. I think you are fortunate that at least you have it on paper in the Constitution of Indonesia. The identity of customary communities, having to prove their link, not their ownership, but prove that the land that their ancestors inhabited belongs to their tribes. There are all sorts of procedural hurdles where a community may have to register with the government, and the government may decide to recognize them or not recognize them before customary law can be implemented. And then formalization of customary law, harmonizing it with state law. I heard several speakers today talk about customary law is allowed, it's permitted as long as there's no conflict with the state law. But what if there is? How do you harmonize that? And what if the customary law practice is very, very important to a community? So there are very strategic legal strategies to use if you confront that argument about customary law conflicting with state law. And then enforcing it. How do you enforce it? Because typically communities do not have their own police forces. So I'm not going to go through this. This is in a recent ASEAN report about on the topic of forestry management, about customary law practices that are being used throughout ASEAN countries. So there is a lot of knowledge here. Cambodia, Laos, Myanmar, Philippines, Thailand. There is a lot of knowledge that has been developed by people in your own region, not to mention in Africa, Latin America. People are going through the same struggle that you are to recognize and harmonize the use of customary law in a way that respects traditional knowledge and indigenous communities. So, maybe you want to have a conference follow-on where you have people from different countries like this one sharing their experiences and giving you the benefit of the lessons they have learned. So that's it. Thank you very much.
Thank you.
One of very important point that mentioned by Professor Warren is about how indigenous people protecting the land and the forest things. So, Bill, as you know, that land and forest is also the house of the indigenous people. You will discuss about the another house, inadequate housing rights for the people. So we will hear some of you the relation between that idea, how the right is really important for the people, also for the indigenous people. And around 15 to 20 minutes, you will explain how important is that. Thank you.
Thank Thank you, Ferry. And I want to begin by thanking the conference organisers. It's a real privilege to be here today. And it's also wonderful to see so many students in the room as well. It's a really wonderful thing to see. And I'll be talking today about housing rights and about the right to adequate housing. One thing I also want to mention is it's really wonderful this conference, the conference organisers have managed to bring together a range of speakers to deal with this topic about legal reform and equitable law enforcement in Indonesia. And it's really great to see a panel of distinguished and expert speakers who are addressing this topic from various different angles. I'm based at the Australian Catholic University in Melbourne, in Australia, and this is my first trip to Indonesia. And I want to thank the conference organisers for their wonderful hospitality for this trip. My professional background is in housing rights. I used to work as a tenancy lawyer, and I'll particularly focus on the human rights found in two international treaties which you may be familiar with: the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Can I have the PowerPoint presentation, please?
And also, Bill, sorry for interruption. Will you grab the microphone so we can hear you? Because you're too tall.
Can it?
Just grab.
Hold on to it. Thank you.
Yeah, you're welcome.
Is the PowerPoint presentation available? So Australia and Indonesia are both parties to the International Covenant on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights. And this means that Australia and Indonesia are both bound to comply with the obligations which these treaties impose. The Covenant on Civil and Political Rights is important. It states that no one shall be subjected to arbitrary or unlawful interference with their privacy, family, home, or correspondence. And it says that everyone has the right to protection of the law from such interferences. The Covenant on Economic, Social and Cultural Rights recognises the right to an adequate standard of living, which includes adequate food, clothing and housing. Thank you.
I think Bill also has the PowerPoint. So that's your. I think you have PowerPoint.
There is
Yeah.
PowerPoints.
So please, you can continue, and we try to fix everything there as soon
Okay.
as possible.
Okay. And what I want to speak to particularly today is the right to adequate housing. And the UN expert body on the right to adequate housing has published a statement, and I'll bring up the text of the statement on the PowerPoints, but it's basically published a statement to outline what is the scope of the right to adequate housing. What does it actually mean under international law? This general comment is called General Comment 4, and it has certain features which I want to outline in the presentation today. The purpose of General Comment 4 is actually to outline to state parties what are their obligations, what do they need to comply with in terms of providing adequate housing. General Comment 4 states that there is a disturbingly large gap between the standards set in the covenants and the situation prevailing in many parts of the world. While the problems are particularly acute in some developing countries, which confront major resource and other constraints, significant problems of homelessness and inadequate housing also exist in some of the most economically developed societies. The United Nations estimates that there are over 100 million persons homeless worldwide and over 1 billion inadequately housed. And this is in 1991. 100 million persons homeless worldwide and 1 billion inadequately housed. Thank you for the PowerPoint presentations. There is no indication that this number is decreasing, and it seems clear that no state party is free of significant problems of one kind or another in relation to the right to housing. The general comment 4 on the right to adequate housing says that the right applies to every person, regardless of age, economic status, group, affiliation, or status. It states that the right to adequate housing means the right to live somewhere in security, peace, and dignity. And it means more than simply having a shelter or having a roof over one's head. The right to adequate housing is derived from the inherent dignity of the human person, and General Comment 4 says it should be ensured to all persons irrespective of income or access to economic resources. This challenges the common perception that housing is simply a matter of personal responsibility or simply a matter of private property. International human rights law brings a new perspective to this situation by emphasising the role of the state and of governments in ensuring that everyone has access to adequate housing. The right to adequate housing is, of course, particularly important for poor and vulnerable members of the community. For example, governments must take efforts to make housing available for those who otherwise cannot afford it. General Comment 4 highlights 7 aspects of the right to adequate housing. Can I move to the next slide, please? The first aspect of the right to adequate housing is security of tenure. This means that government should protect all people from forced eviction or removal from their home. And this means even if they're living in informal settlements or living in temporary accommodation. So security of tenure is a really important part of the right to housing. Secondly, adequate housing includes access to essential resources such as safe drinking water, cooking, heating and cooling, sanitation and site drainage. Thirdly, affordability. Government should ensure housing is affordable, for example, by providing subsidies and housing finance to those in need. Fourthly, habitability. This includes structural safety and protection from natural elements such as rain and wind. Fifthly, accessibility. Government housing policy should prioritise groups in particular need, such as women, the elderly, children and people with disability. Sixth, location. Housing must allow reasonable access to employment, school, healthcare and community activities. And finally, cultural appropriateness. Housing must be culturally suitable for the occupants, for example, according to family size and configuration, and it must be suitable to the cultural needs of the people occupying it. Fulfilling the right to adequate housing, of course, depends on the availability of sufficient resources and therefore of the level of development of each country. External factors such as restricted budgets affect what is considered adequate in terms of states' compliance with the right to housing. Adequate housing also depends on the allocation of adequate resources and also on government policy framework. And I want to come back to this topic about policy framework in a moment. But this generally requires each state to have a coherent national housing policy developed in consultation with stakeholders, including homeless people and people on low incomes. States must monitor the effects of their policy, for example, on reducing homelessness and providing housing for members of vulnerable and disadvantaged communities. And states should ensure that domestic legal remedies are available when the right to adequate housing is breached. And this includes through court proceedings and also to other complaints mechanisms, for example, concerning unhygienic or unsafe housing or any discrimination which is happening in relation to housing. So to summarise in terms of the right to adequate housing, This right is internationally recognised through the 2 international covenants which I've mentioned, and it has various aspects including security, affordability and accessibility. Australia and Indonesia are both state parties to the 2 covenants from which the right to adequate housing derives. Therefore, they both have obligations under international law to provide access to adequate housing. I want to talk briefly now about the situation in Australia and also briefly the situation in Indonesia in terms of state compliance with the right to adequate housing. Firstly, Australia. Can we move to the next slide, please? Australia has a developed economy and a higher per capita income. However, Australia has a large and growing number of homeless people, and housing is increasingly unaffordable for many people on average incomes. In Australia, housing is largely regarded as a matter of property law, and it's largely regarded as a matter of personal responsibility in terms of housing and standard of housing. So, for example, under Australian law, if a tenant breaches their rights, then they can be, if they breach their obligations, for example, by not paying rent or by damaging the property, then they can be quickly and easily evicted under Australian law. Public housing in Australia is provided by government, but the demand for public housing far exceeds supply and the demand is steadily growing. The Australian government provides financial support to people on low income living in private rental accommodation. Now, moving to the situation in Indonesia. The Indonesian constitution, the 1945 constitution, provides that every person has the right to live in prosperity, physically and spiritually, to reside and enjoy a healthy environment. This is in Article 28H of the Constitution. This empowers and requires the Indonesian government to provide access to adequate housing for all Indonesian people. The Indonesian government has a housing policy, and I'll come back to this in a moment, which includes a mix of public and private sector initiatives, such as subsidised mortgages, public housing programs, and various forms of regulation in relation to development and housing. There are programs for making housing more affordable, particularly for people on low incomes. In Jakarta and in other large cities, there are informal settlements where people on low or no income reside. And people in informal settlements, of course, live in constant fear of eviction, and there is community resistance in terms of forced removal from people living in informal settlements. I want to talk a little bit about eviction protections, and then I want to come back to a recent constitutional court, an Indonesian constitutional court decision. As I mentioned, the right to adequate housing is particularly important for people, for members of vulnerable groups in society, such as women, children, older persons, and people with a disability. There is a general comment on forced evictions published by the United Nations Committee on Economic, Social and Cultural Rights. Social and Cultural Rights. This states that evictions should not result in individuals being rendered homeless or vulnerable to the violation of other human rights. Where those affected are unable to provide for themselves, the state party must take all appropriate measures to the maximum of its available resources to ensure that adequate alternative housing, resettlement or access to productive land, as the case may be, is available. Of course, human rights can be limited, and the right to protection from eviction can often come in conflict with other rights. So protecting one person's right to not be forcibly evicted can, of course, come into conflict with property rights, for example, the property rights of landowners. And this brings us back to one of the themes of this conference, which is on not just procedural protection, but also on substantive protection. And this also maps across protection from forced eviction. So protection from forced eviction involves a substantive aspect, which means there must be a legitimate reason for moving a person from their home, and this reason must be proportionate to the harmful consequences. The procedural aspect means that people must be given adequate notice of a planned eviction, and they must have the opportunity to challenge the eviction through a legal process. As I mentioned, these processes do involve limiting the property rights of landowners, for example, by preventing a landowner from immediately evicting renters or informal squatters from privately owned land. However, the right to adequate housing means that a person's home is not considered to be merely a commodity or a privilege, it is a human right. In terms of realising the right to adequate housing, the UN Special Rapporteur on Adequate Housing has said that largely this comes down to changing mindsets and changing attitudes. Government lawmakers and policymakers and decision makers need to become familiar with human rights and also with the duties which human rights impose, particularly the duties which they impose on the state itself. Governments have a duty to assist vulnerable members of society by providing access to adequate housing. And I want to move now to talking about a recent decision of the Indonesian Constitutional Court, which you may be familiar with. And this decision was given on the 29th of September, very recently. It involves the Public Housing Savings Program, which was said to be an implementation of the government's obligation under 28H of the Constitution. And the Public Housing Savings Program was designed, it was requiring people to contribute their income to a savings program which was designed to provide them with housing. And it was basically a 3% of a person's income was required to be put aside in order to be the fund for providing housing. So the Indonesian Constitutional Court recently invalidated the Public House Savings Program because the Constitutional Court regarded this as a mandatory process rather than being a voluntary savings program, and therefore it constituted a levy on workers rather than being a voluntary savings program. The court gave the government 2 years to restructure the housing policy. And this is a significant decision because it marries up with what I've said earlier about the obligation falls on the state in terms of providing the right to adequate housing to people on low income and also conferring the protection which people need in order to have access to adequate housing. So in conclusion, this presentation has outlined the key features of the right to adequate housing as it's been articulated by United Nations bodies. Scholarship on this right is developing, and it's necessary for all of us to understand the scope and nature of the right to housing so that we can inform the government and policymakers in Indonesia and Australia and other member states of the human rights treaties. Thank you very much.
I do hope President Prabowo hear your presentation because he promised will give like 30 million free house for the people. So probably you can give your presentation to him. The relation between your presentation with Professor Ahmad Buang is zakat probably one of the solution related with the housing. Even though in Indonesia, zakat also political things that involved in many election. But let's hear how we can use zakat to protect everything and also the giving people rights, especially adequate housing or anything else. Please welcome the presentation for Professor Ahmad Buang around 15 to 20 minutes.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat petang. First of all, I'd like to thank the organizer for inviting me to this important seminar or conference. And I'm lucky and honored with the great scholar here today in this great campus of University Andalas. And my presentation will be the last one for this afternoon. I promise you will be short, and because I can see many of us are retired or this long day presentation. To answer our chairperson question whether zakat can solve issue housing, of course, the zakat can solve this problem by providing at least house paying the house rent instead of house ownership. What happened in Malaysia is that the zakat authority, they provide uh, rent assistance to the poor. So the poor will their house rent will be paid by the zakat authority. So that one of the solve that the solution to the issue of house. But the issue is that, Mr. Chairman, the poor, when they receive zakat, they do not want to be rich. They want to stay poor all the time because because they want to receive the assistance every year. So that the issue, the moral hazard of receiving zakat. So my presentation today is about accountability and also about equitable, perhaps in term of poverty, in term of wealth. So there are two issues here. So I will not go to the slide one by one, but I want to just discuss the theme of the topics. So the next slide is that can you move to the next slide, please? Okay, okay. You need to control my. Oh yeah, okay, 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 okay. Yes. The next slide is that the foundation of zakat. I think we know that zakat is a religious obligation. If the one of the five pillars of Islam. So the issue here is not easy to ask people to donate. Okay, so when you have money or property, it's not easy to take from you voluntarily, except through taxation. That's through law. Then you have to pay because there's a law. But to donate voluntarily is not easy. So what here is that zakat is one of the Islamic pillar. So people pay zakat because they believe in the system, because of their faith, not because of any law that pressurize them to pay or that force them to pay. Normally, in most of the Muslim Islamic country, people pay zakat because of their belief, of their faith. But in Malaysia, there are two types of zakat: zakat fitrah and zakat property, zakat mal. Zakat on property, zakat on oneself, we call zakat fitrah. The zakat on the property is voluntary. It's up to you to pay. There's no law, there is no regulation that require you to pay. It's voluntary. But on the zakat fitrah, some state in Malaysia, because we practice federalism, so the authority on the Islamic matter rests on the state. So there's in some state say that you need to pay fitrah, so you can be penalized if you don't pay fitrah. But fitrah is very small, only about I think $1 per year. Okay, very small. Now probably about $5 per year. So it's very small. So all people can pay fitrah. Doesn't matter. So meaning that payment of zakat is something from yourself, and then that creates the issue of accountability and come of equitable distribution to the poor. Next slide, please. Okay, perhaps I think this one. Okay. Okay. So the issue here, the main point here is that the philosophy of zakat is self and wealth purification. And then in certain aspect of zakat, people say that when organized officially, it will serve as complement to public finance. So in the Muslim society, for example, in Malaysia, so zakat serves as complementary to government projects and government assistance to the needy in that respect. Although zakat is purely a Muslim-based social net program, but in certain aspect, it has some impact and some assistance to the non-Muslim as well in Malaysia. Because you see that, for example, in case of flooding, because flooding does not recognize Muslim or non-Muslim. So in that situation, zakat also assists people that affected by this issue of flooding. The next one is the okay, yeah. This issue of accountability in term of payment is not that an issue because the payment is voluntary. The issue of accountability when it comes to distribution. Okay, how to distribute. Normally in zakat management, in certain state, there is an authority that manage zakat collection. Okay, so certain country zakat payment is direct from individual. You pay personally to the people that you want to pay. But in certain country like Malaysia, and as I also think in Indonesia, there is an organization that organize collection of zakat. Then the issue of accountability. Okay. So, to avoid this issue of accountability, there must be some. There are three principles that that this the slides here. One is a guidance. You need a clear guidance, a comprehensive guidance or instruction from to in order to ensure accountability of zakat distribution, and then fairness, and then compassion. The fairness part and the guidance part is that uh, in our experience in Malaysia is through the regulatory control and supervision. What I mean by regulatory control and supervision is normally to reporting and through auditing. And the compassion and responsibility normally is because of the religious belief that you should do some, because the punishment for abusing zakat is much worse than abusing public money because it's religious money. So that is the compassion. And the next one, the next slide is the significant of zakat. I think this one, I'm not sure how to operate this one. Okay, okay. Yeah, this one. Uh, the collection of zakat normally organized by the organization is have some genesis from the early day of Islam, because we know that in the early day of Islam, the Prophet Muhammad sends zakat collectors to collect zakat for the government, for the state. So they have some genesis from the history of Islam. So that's why we continue that practice until today. Okay. This is when we have an organization that organize that collect zakat. So there is some there's three things here you mentioned here. First, the collection must be done in through a legitimate legal process, meaning that you need a mandate from a law that allow you to collect zakat. You must not just collect like that. You can pay zakat, no problem by yourself. But in order to collect zakat from the public, from the Muslim, you need some legal mandate. That's what happened in Malaysia. Nobody can collect zakat except through legal mandate. And then for the purpose of transparency, you need to have the effective governance and processes of your zakat collection. And the other thing is that in order to ensure that you must comply with the rules and guidance of zakat collection and distribution, there must be a good governance in your organization, meaning that you have the board that authorize all the policy. You have the manager that do all the process, and the end of the day, all that thing must be audited for the transparency purposes. This one is a legal framework of the zakat organization for the to ensure accountability. The same thing. Yeah, the same. I just repeat the same thing. It must be clear measure of the law, and then it's the principle that in Islam, property is kept, so you cannot take from other property except through process that is legitimate. And then accountability mechanism. So in Malaysia, for example, to ensure that there's accountability, there is a punishment lah for people that collect zakat without permission. There will be some penalty or punishment lah. It can be prosecuted lah in our law. I don't know about Indonesia, but in Malaysia, if you collect zakat without permission, you can be prosecuted. And then the protection of beneficiary rights. So as I said just now, it's the duty of the zakat organization to produce report annually and to be subject to audit internally and independently. So you have the internal auditor, you have also independent audit that audit your processes. Okay, so that's why to ensure protection of the beneficiaries. So this one fairness, I will go quickly. So uh, so what is the most important thing in zakat collection is to help the poor. So the most important in zakat collection is to help the poor, to not to eradicate, but to alleviate poverty, because we cannot eradicate poverty. But what we can do is to alleviate poverty. So our concentration and our focus is to reduce poverty among the society. That the focus of zakat. But of course, there are also other social impact of zakat, especially in terms of now we have this ESG principle, environment, sustainability, and governance. So these two can be used to prioritize zakat, but focus to the poor and needy. And then in Islamic principle, there is a maqasid or five necessity also normally applied through when formulating this priority. So do we align the maqasid with the ESG in order to produce what is that is most important to help to be the zakat fund can be used to achieve this goal. And then the most important thing is adherent to Islamic law. And in Malaysia, before zakat is paid to the beneficiary or to recipient, it must be approved by the Council of Scholars. Scholar will check whether this payment to the recipient is complied or is accordant with Islamic law. Okay, so that is to ensure that the payment made by the zakat payer is something that is legit according to the Islamic principle. Otherwise, people will question. So we need the approval of the scholar before we release the money to the recipient. This one also the important here that I want to mention here the okay, monitoring and oversight. The some issue in zakat is issue of favoritism. Okay, your is bias sometimes because you know somebody you favor some people or some group of people. So this also help to reduce to prevent favoritism and also corruption in while managing zakat fund. Okay. Okay. Yes, the same thing, educate government, because the in the past, because it's a religious payment, can I stand over here? uh, because zakat is a religious obligation, people tend to pay only to the imam, to the ustaz, you know, okay, because they believe that when we pay to ustaz or to the imam, we will receive more pahala, you know, more rewards, okay, because we pay to the ustaz, and then we left all the poor. The poor have nothing left because all the payment go to the ustad, because we believe that we will receive more rewards. In that, in the past, what happened? So what happened is that because what? Because there inadequate governance for the oversight of zakat payment. Okay, so alhamdulillah today nobody is left. Nobody is left. So the zakat organization will try best to find poor people. And then the other aspect is that the issue here is the challenges. Largely to when we talk about efficiency and misallocation of fund, largely to the poor management of zakat proceed undistributed. In Malaysia experience, uh, you could say you collect 1 million, 400 undistributed left in the fund, not distributed. Because the principle is that in zakat, once you collect, the money is not belong to you. The money belong to the recipient. You must distribute as fast as possible. But what happened in Malaysia, I don't know about Indonesia, uh, most of the time, 50% undistributed because poor in the management to identify the poor. And then the last one is also because of the records of the poor is not maintained very well. And then we have to you know identify the poor. And then the other thing is that using outdated poverty line. Okay, so because of the inflation and other many things, perhaps in the old day when you have salary about 1,000 ringgit per month, is considered not poor. But in Malaysia, currently 1,000 ringgit per month, you cannot do anything. But they're still using that poverty line income. So people that with income of 2,000, 3,000 ringgit are not considered poor and not be considered as poor that should receive zakat assistance. So that is using outdated poverty line. But this today already we already they overcome that one because to be considered as poor, you must at least below a poverty line. In Malaysia, I think now it's about 3,000 ringgit. Anybody that income below poverty line, 3,000 ringgit, is considered poor and can be paid from zakat, can be assisted from zakat fund. Okay. Sorry, I have some more, very quick. This one centralized. So I say you know centralized authorized collection. Because to ensure accountability, you cannot just ask anybody to collect, and then regulation and standardization, and then also the accountability and distribution. Yeah, the same thing. The emphasis here is to penalty and punishment. The issue of technology now in certain now because of the technology, it's very easy to pay zakat. Okay, but here the challenge here is that in the country that lack in the infrastructure and cyber technology, and also because the poor probably don't have this accessibility to use this highly modern technology and data monitoring. Okay, this one, okay. Although I said just now, zakat is a voluntary collection, But from year to year, the zakat collection increased every year. So last year, in one of the state in Selangor, the collection is about 2.2 billion ringgit, about roughly 7 trillion rupiah in one state. Okay, so the increase of the payment is normally to advertisement and communication. Okay, and then okay, and also the management of zakat or the organization of zakat now in Malaysia has been transformed into sort of corporate body like a company. They work like a company, like bank to collect money. Okay, so very efficient. This is a Malaysia scenario, so I think I already mentioned. But here in Malaysia, the last point is that zakat payment is reputable from personal income tax, and company that pay zakat receive some tax relief. So that is some incentive from the government. So if you pay zakat, so your zakat payment it can be rebutable from your income tax, and the company there will be some tax relief. So there is some incentive people to pay zakat. Okay, and some people sometimes they use this one to avoid to pay tax. They pay zakat more than tax. Okay, and this one last one, inshallah. Sorry. Okay. Okay, I say just now the impact of to the to the impacts of accountability and equitable wealth distribution is that in Malaysia that this zakat has provide jobs to the poor because of the training and education. So all the people, I mean the family lah, the family of the poor being trained and also sent to university for training and education. And as you know, education is a key to progress lah. After you receive education, you can move in your academic ladder up. And alhamdulillah, after a while, these people has gone out from the circle of poverty and become they can sustain themselves, no longer receive zakat after being trained and receive education. Okay, and as I say just now, yeah, small business job opportunity and training, and also one more example is in Perlis, Malaysia. Perlis is one state in North Malaysia near the border of Thailand. So in that state, the distribution and the collection of zakat has a direct involvement of the royalty and palace, making an impactful effect of zakat to both collection and distribution. When a royalty involved in zakat collection and payment, so the impact is very strong there. And the last one is that when a corporation pays zakat, say like a bank or financial institution pay a zakat, say 20 million ringgit. So normally what happen, the zakat authority will allow the company to pay that zakat, a part of it by themselves. The program they call wakalah zakat. Okay, say a school or university, they collect zakat from their staff, and then they go there, and all the collection is given to the zakat authority. But in certain situation, the zakat authority will allow the university to directly pay that collection to the recipient. And then because why? Because the university probably know better who will receive this assistance. It's normally to the student lah. Okay. And so the takaful company. So the other thing is the one more that I want to show here, the impact to the social is that insurance company. We call in Malaysia Islamic insurance, we call takaful. So takaful company also pay zakat, and this under the scheme of wakalah, they provide this what we call as macro takaful, meaning that in we have this medical insurance, medical takaful. So the poor, their premium will be paid by zakat collection. The premium, the premium of the medical insurance or medical takaful. So that will help the poor in terms of health benefit from the zakat. So there are many programs that zakat can contribute to the equitable society in Malaysia. But as I said just now, it's only complementary to the bigger picture of the state apparatus and state responsibility. It's not something that try to replace the state responsibility, but only complement. Because we do not want to make that the government will release all the responsibility to zakat authority. So that's it. My presentation. My apology for taking some time. Thank you very much again for the invitation, and hope that you get benefit from my presentation. Sekian, Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much. You mentioned sometime Indonesian better than Malaysia on collecting and distribute the zakat things, because only around 50% they can distribute well the zakat. Is it? This is the way Indonesian did. We almost distribute 90% of zakat. How they did? They give some social assistance to the public when the election come. We call it pork barrel. That's not the correct things, yeah. So we have a problem each other. You explain how important the accountability. That's also a problem in Indonesia, and in Malaysia it's not the real problem. The real problem how to distribute. We can solve, but the wrong way. Okay, 2 questions, because tomorrow the attendees will discuss in another meetings at a hotel. So we only have like 2 questions. I give a chance to the audience if you have a question. A lot. 1, 2. Yes, please. Please telling your name and giving very, very short question.
Yes. Hello, good evening. Assalamualaikum to the panelists. My name is Muhammad Aiman. I am Malaysian. I'm from Malaysia. So I have a question to Prof. Warren. I appreciate your presentation on how we should appreciate customary law. Quite similar to the Indonesian constitution, Malaysian constitution also recognize customs as part of our legal system, but the status quo now is not really fully appreciated, especially by some of the higher courts in Malaysia. So one of the argument against of customary law is that the feature of customary law is unique to the community, and sometimes it creates uh, irregularities between one community to one community. And some legal jurists have argued that the features of law must come with its uniformity across the land. So how do we respond and how do we react towards those legal arguments? Thank you.
Sorry, to whom your question addressed?
To Prof. Warren, and I appreciate any input by
Okay.
the other panelists as well.
Cool. Well, that's, you want to answer directly? Okay, go ahead.
Is this on? No, I'll use yours. No, that is actually people who understand customary law understand that it is beneficial to have different applications in different communities. That is the purpose of it. That is the point of it, is that in certain areas, and my colleague was asking me at the end of my talk, so how do you harmonize customary law with state law or constitutional law? And that's a complicated, you can negotiate that in different ways, but in different communities, they can, the state government can allocate powers to the local communities to deal with family law or custody law or divorce or certain areas that the government is willing to allow communities to decide for themselves. But there is no rule that customary law has to be equal and the same, because customary law itself is not spelled out in the Constitution. It is very, very helpful if customary law is recognized in the Constitution. The legitimacy of it is recognized. And this study that I mentioned to you that was put up by this NGO is super useful to read because it's very long. It's like 100 pages, but the text of the article is very short, maybe 21 pages. And then they have annexes that demonstrate how different countries have harmonized the customary law with the state law or the constitutional law. But the idea of customary law historically and culturally is that every community should have the right to decide for itself those particular issues. If it were going to be uniform across the country, it would not really be customary law. It would just be a parallel pluralist legal system, right? Because it would not be localized. Customary law is meant to be localized to accommodate to the needs of that community, especially in multi-ethnic states, multi-religious states, multi-linguistic states. Indonesia is a perfect example of that. I've forgotten, how many languages do you have? 100 and something? Yeah, just many, many languages. So how could you develop a customary legal system that is uniform across the country? It would not make sense. Would Aceh want to live in the same customary, legal world that Jakarta does or Yogyakarta or Bali? I don't think so. They want to live, according to their own values there, right? And the rest of the country would not want to live according to the customary rules of Aceh because they have different culture and stuff. So I think the question about let me say this. The question about whether customary law should be uniform across the country demonstrates an unfamiliarity with customary law. All right. It is meant to give power and responsibility in certain issues to local communities to decide for themselves and live according to their local values. There are certain things that the government is going to want to keep away from customary law, and usually they are economic issues or they have economic consequences because the government's interested in, economics. In some communities that I have worked with where there's customary law and state law, the local communities have delegated criminal law in serious criminal cases to the state. If there's a rape, if there's a murder, if there's something serious, the community gives it to the state and says, you can prosecute this. But if it's a case of a theft or drug use or a fight between neighbors, where there's punching or something like that, those are perfect cases for the idea of the community to come together in a sentencing circle or a customary house or something and sit down and say, wait a minute, what's going on here? How did this happen? Are the parents not doing their job? Are the kids rebelling? And then the community can come together and decide how to deal with that. But what works again in one community is not necessarily going to work in another community. So I think that whole question is just if you'll excuse my language, a question of ignorance. Not your question.
Last question, please.
Thank you for the opportunity. My name is Kaza, and this is a question still for Miss Warren. And thank you for the presentation before. I really appreciate it, and I strongly agree with the Miss Warren about how important the customary law in Indonesia. But I always see and found that customary law, particularly in Indonesia, faces significant challenges, uh, such as the state itself that violates the rights of indigenous people. And I think one of the reason for this is because we are lacking of the protection for the communities. Like, for example, we have a national human rights commission that serves as a place for people to report the human rights violence, but we don't have any specific body or place to report any violence about indigenous rights or communities. So, I just wanna know or hear your perspective about how do you think it is important to a country like Indonesia that have so many customary law to have a body that serve like Komnas HAM that protect only for indigenous rights, and or do you think we could do something else, or do you have any ideas so the customary law in Indonesia could gain power as the law in general? Thank you. That's my question.
So I want to make sure I understand the question. What do you do? Is there a body where violations of customary law can be reported? Is that the question? Yeah. In front of the state. Yeah. Well, so I think we have to be very fact specific with this question. Is the state violating customary law? The state is the one that is not protecting customary law?
Let me answer this question. Yeah, in some cases, the government, by forcing some communities to take the ownership of the land, miss, and it happened in Indonesia in like a very small island, and it's really hard to find about these cases unless we are really looking for it.
Seizing land. Oh, so, well, that is a case for the courts, you know. So, again, I think we're sort of confusing a lot of ideas here right now. If the state is violating the rights of indigenous people by seizing land that has been delegated to them, allocated to them, then the remedy is to go to the courts. All right. So there has to be legal protection. We're not talking about the right of people to follow their own customary law right now, if I understand your question correctly. We're talking about the state violating the rights of indigenous communities in customary law. So in that situation, having very specific language about what the rights are of customary communities, indigenous communities, to own their own land, to manage their own land, to manage land that historically their tribe and their family and their kin have managed. That is a legal issue that should be protected on paper, you know, in the laws. And if those laws are being violated, the indigenous community members can go to court to challenge them. You know, but if it's just customary practice, and it's not reduced to writing, then you may not have a legal remedy. That's the problem. You know, enforcement is one of the very tricky parts of customary law. If you are adjudicating a criminal case, for example, and the local community has the right to decide it for itself, and they do, and that's okay with the state government, then enforcement comes because the community will enforce it. The community will go back to the family of the person who committed the crime. The community can refuse to sell to the family of the person. I mean, there are community mechanisms, community remedies that the community members can decide for themselves if it's something that they have within their jurisdiction. One of the benefits of customary law in criminal matters is that very specific remedies can be tailored to the community. So if somebody, a teenager, steals something from a store, right? And that goes into the sentencing circle or the customary house to decide. Maybe the community will say, you stole something from the community. This makes us feel very unsafe. So what you are going to have to do is clean the streets for a year, or you will have to cook a big dinner for everyone, or you will have to do volunteer work in a shop or something. The punishment is something that will help the community regain the trust of that people. But the community can decide what that punishment is. You know, you're not looking to the capital. You're not coming to Jakarta if you live all the way in Surabaya, you know, because a different punishment is appropriate there. So there's a lot of flexibility in customary law. It's very, very flexible, and that's one of the benefits. But again, if you're talking about the state violating the rights of the indigenous community to own their land, to manage their land grabbing, maybe unfortunately that has to go to court. I mean, it's a theft that's being committed. It doesn't really matter whether it's an indigenous person or, you know, a mainstream Indonesian person. It's a theft, and it should be prosecuted.
Thank you. We need to stop. I know many idea pop up a lot in our discussion, but each specific idea we'll discuss again tomorrow in several room in our hotel, and we will continue our discussion tomorrow. Thank you very much for the 4 speakers. I need your clapping hand, please. Thank you very much again. Still sitting around here and open your eyes. That's help. Yeah. See you tomorrow. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, distinguished Okay, this session giving applause to our speakers. To Dr. Bill Swaney from Australian Catholic University, and also to Professor Dato Ahmad Hidayat Buang from University Malaya, and also to Professor Christy Warren from William and Mary Law School, Virginia, USA, and also to Nur Sharifah from Oregon, Nusantara. Okay, in this session, we will also giving a certificate to our speakers and also doing a photo session. Okay, and also we would like to say thank you to our best moderator, Mr. Ferry Amsari SHMHLM from the Faculty of Law Universitas Andalas. Okay. Okay, the next we do a photo session with all moderators and speakers. Photo session. Okay.
Okay, thank you so much, Dr. Nani, and our moderator, also the speakers. Well, ladies and gentlemen, that concludes today's international seminar of the first Andalas Law Conference. On behalf of the organizing committee, I would like to express our deepest gratitude to all distinguished guests, speakers, and participants of making today's event a success. We will continue tomorrow with a call for paper presentations at Santika Premier Hotel, Padang. Thank you and have a wonderful day.
Assalamualaikum
Assalamualaikum
warahmatullahi
warahmatullahi
wabarakatuh.
wabarakatuh.